Checking for sound. 1, 2, 3. Thank you.
Recording in progress.
Good morning. Buhle, Alan, are we correcting so that we can start with the meeting?
Good morning, Chair. There's currently 5 members on the platform, so one more.
Okay. Noxy, where is Zanen? No Giji. No Giji, I'm morning up.
Yeah, okay, let me check them, Chair. Good morning.
Morning.
Chair, it's 6 members.
Okay, we're correcting now. Okay. Let's start with our meeting. Thanks very much, honorable members. Let me first thing first. Let me officially open the meeting. Welcome members of the Standing Committee Finance. Welcome National Treasury. I'm not sure if the DG is in the platform. And welcome to all the stakeholders who are here on the platform. Welcome all the support teams from Parliament, and in particular the team that support the Standing Committee. Welcome the media, the public, and everybody who's in attendance. Are there apologies?
Yes, Chair. Long-standing apology from Mr. Sarupin, and then Dr. George apologized as well. Thank you.
Okay. And you also have stakeholders that apologize, isn't it? Is it Saika, Pari, Watermayor?
Yes, Chair. It's Saika, Pari, and Ron Watermeyer. That's the only ones that apologized. Some stakeholders indicated they will be here, others just never said anything. So I'm assuming that they will be in attendance. Thanks, Chair.
Okay, so let's record those stakeholders that have apologized. Thanks again, honorable members. Today, we are meeting again to get the response from National Treasury after we had public hearings where stakeholders have made submissions orally and in writing, and also the inputs that came from members of this committee during that session of public hearings. Let me acknowledge that we have received a comprehensive response on issues that were raised by the stakeholders and members during public hearings. A response coming from Treasury, we have distributed the response from Treasury so that by the time stakeholders and members attend this meeting, you should have the content of what is contained in the response of National Treasury, so that we have a fruitful engagement. This is a very crucial bill, which is in the interest of the people of South Africa. Let's move then to the next item, which is the response by National Treasury. I'm not sure who's leading the team, whether the DG is there or whosoever is leading the team. Can you take over and make a presentation in regard to the response on the issues raised by stakeholders and members of Parliament? Over to you, National Treasurer.
Good morning, Honorable Chair and Honorable Members. I am Mendon Tswahlana. Apologies for the DG. He will be joining us later. But we are here we will start with the presentation. And in terms of the presentation, we do have also a framework that we'll be talking to that relates to Chapter 4. The third issue would be going through the actual comments that we received and the responses. Mr. Matebula will take us through on the presentation, and the other colleagues will do the other presentations. Thank you, Honorable Chair.
Good morning, Chair, and also good morning to the honorable members.
Kalanga, is it me who has a problem of network this side, Alan, or is it National Treasury?
No, Chair, it looks like they frozen.
Yes, they are the ones, Chair.
Okay. I can see the screen, but I can no longer see them here in the platform. It looks like they've got a problem. Can you call them, Alan and Bush, that they sort out their system?
I don't know if you can hear me, Chair, now. Am I
Lungisani sound na connect.
okay? Thanks, Chair. Can I proceed, Chair?
Yes.
Okay. No, Chair, this is, of course, a response to the public comments culminating from the public hearings that were held on the 12th and 13th of September. And at the direction of the committee, we were then directed to go back and consider all the written as well as the presentations that were made. So this is what we have done. But I must, Chair, first indicate that we received quite a number of submissions across the board, and we tried to cover as much as we could, given the time limitations. And what we then put together are is the comment matrix, as well as a report which summarizes some of the issues, including the chapter 4, which has been presented as well separately, and of course the list of all the stakeholders that made presentations. So all these documents were forwarded, Chair, to the committee secretary yesterday. So as we go through the presentation, and I'm sure the committee members would obviously be in possession of those documents that we second. And we must apologize, Chair, that we may have submitted a bit late, but at least it is what it is, and also the presentation came in a bit late, but we just want to apologize upfront, Chair. Now, the Treasury team then set and consolidated all the responses, written responses, and put that together, I mean, in an Excel spreadsheet, verbatim, right from the written responses, verbatim copied into an Excel spreadsheet. And after that, then a process of consideration of the responses then took place. And we've tried to respond between that period from 14 September, I mean, the processes that I'm talking to, 14 September up to yesterday, Chair. And where relevant, and of course, based on comments, certain amendments are proposed to be made to the PPP for consideration of the committee. Then, as indicated, Chair, there were about 112 stakeholders with approximately 2,200 lines if you take the comment matrix, that Excel spreadsheet. And now, how then we approach this whole process of responding, we focused on the themes that emerged during the review of the comment process. And we also highlighted the divergent views expressed by commenters. And consequently, Chair, it was important to assess these comments in light of the Constitution and government policy objectives. Now the following slides that we will present, of course, do demonstrate the overarching themes and also outline how these comments were addressed. Now, in chapter 1, Chair, this chapter deals with the definitions, the objects, application, and administration of the Act. Now, we're summarizing at least here a few of what came out from the stakeholders. We say stakeholders questioned the definitions, stating, among others, that terms are not properly defined, offering alternative definitions or proposing new terms to be defined within the clause. And this is across all comments that we've attended to so far, Chair. Now, such as I'm just picking up on a few of the examples that we have. For instance, Chair, there is an issue of immediate family members. Stakeholders proposed an exclusion of the term previous spouse from the definition of immediate family members, as it may affect the socio-economic life of the bidder. And as a result of all the comments, I mean, based on what the stakeholders have said, we then proposed the redefinition of immediate family to mean the spouse, civil partner, life partner, children and stepchildren, parents and siblings. The Chair might know that in the bill that you have in your position, this definition of a family member was quite long. For instance, Chair, we debated on the issue of the issues around that definition ourselves when we received these comments, and even debating issues of stepchildren and or children of step siblings, etc. It's quite long, a long definition. And that's when we said, perhaps our law should have the eyes to the cultural diversity. Because in different cultures, for instance, in my case, Chair, a child is a child. So whether it's a stepchild, but to me, that is a child. It doesn't matter, it's a child. So we debated those issues, but eventually we decided that we will, because of course, this is the norm, include stepchildren as part of that. But you will see that the definition is much shorter than it was previously, for reasons that I've just made now, Chair. The one other issue, Chair, that we touched on was the infrastructure issue. The stakeholders held the view that the definition of infrastructure should be expanded to include digital infrastructure. And a view was that infrastructure is quite broad and goes beyond just the physical infrastructure. I think there is also an ICT infrastructure which could be both tangible and intangible in nature. And as a result of that request, Chair, we also proposed a redefinition of infrastructure accordingly. So there's a definition of how we then define infrastructure. The one other issue on Chapter 1, Chair, is transformation. This came out strongly across a number of submissions, of course, and the stakeholders raised the view that the term transformation should be defined in the bill in the context in which the term is used in the bill. They have the view that the definition will provide the required clarity and avoid ambiguity, and transformation means different things to different stakeholders. And as a result of this kind of request to define transformation, we then defined it to mean a process of change that seeks to redress the imbalances of the past, including the achievement of socio-economic objectives. That's how we defined the Chair, and then we included in the list of in clause 1 of the bill. One other issue, Chair, lastly, just as an example, is the issue of value for money. Some stakeholders, of course, were of the view that value for money should be prioritized over all other policy objectives, as they believe that preferential procurement equates to the least cost, whereas others are of the view that value for money and other policy objectives are not mutually exclusive, and that value for money must be defined as achieving all the objectives of Section 217 of the Constitution, all the subsections thereof. And as a result of these conflicting views, Chair, it is proposed that the value for money be removed from clause 1 and replaced with efficient, effective, and economic use of resources in clause 2A of the bill, to retain consistency between the wording of the bill and the Constitution, especially Section 195 of the Constitution. Then in Chapter 2, Chair, this particular chapter deals with the establishment of the PPO, the PTs, their functions, and also the functions of procuring institutions. I'm not so sure, Chair, if you can hear me still. Now, the stakeholders were concerned with the location of the PPO within the Treasury to ensure that it remains independent. I mean, there was that complaint to say, perhaps if it sits within the Treasury, it might not be independent. And we noted this comment, Chair, without any solution other than what is already provided for in the bill, in clause 4 of the bill. The other issue that stakeholders raised is an issue with the PPO and the provincial treasuries issuing binding instructions which may contradict one another and create unnecessary confusion in the system. Now, a proposal is made to subject instructions to public comments prior to implementation thereof. Further, Chair, the PTs, which are provincial treasurers, will not issue instructions that are contrary to the ones issued by the PPO. So the first part is instructions should be published as a proposal for public comments. And then, of course, also the treasuries should always ensure that the instructions they issue are also subjected to the same process and also to not be contrary to the ones issued by the PPO. In addition, Chair, regulations to the bill, which would be developed, of course, in terms of Section 58 of Clause 58 of the bill, would also be published for comments and be subjected to the parliamentary process. So this is how we then decided to deal with this particular issue, Chair. Then the next issue, Chair, under the next chapter, which was chapter 3, that deals with procurement integrity, prohibition of certain practices and debarment. Most comments in this chapter were raised around the deterrence of corruption and the protection of whistleblowers. However, the view is that issues relating to corruption and the anti-corruption agency require collaboration with law enforcement agencies and the relevant departments within the justice cluster. It is also proposed that amendments to the Protected Disclosures Act be made to enhance the provisions which relate to the protection of whistleblowers. So that's a position, Chair, that a proposal that we're making. There was also, Chair, a consideration of automatic exclusion from submitting bids by specific persons. And the Chair, if you look at Clause 13. Now, we also looked at this clause, this particular clause has far-reaching implications and may be difficult to monitor or identify in many instances, especially, Chair, for the reasons that I've mentioned earlier on around immediate family members. Now, however, some submissions, Chair, supported this provision. Now, Chair, what we're then proposing is that Clause 3.1b and 13.3 should be provided for under Clause 11 to avoid automatic exclusion, for instance, of leaders of political parties and other family members. Let me just quickly explain this one, Chair. In respect of automatic exclusion of immediate family members, we looked at this in two respects, Chair. The first part is that if you consider that many of us come from small dorpies, villages, and rural areas, so we may find that in a particular small dorpy, there is only one economic activity, maybe through the local government or municipality. Now, if I am working in that municipality as Matebula, and I, of course, happen to sit in the committees that take decisions on procurement. So what we are saying, these people, my family members, would, of course, be prejudiced in that process. Because then it means they are related to me, and therefore they can't do business with. Of course, they can't submit, bids to the states. And we thought that could be problematic in the sense that where else must they go to earn a living? So that's the first part that we looked at, Chair, to say rather than automatically excluding family members from submitting bids, let this process be moved to the declaration of interest that is under clause 11, so that if I sit in a committee and one of my family members happens to submit a tender to that municipality or whatever, then I need to declare, because it's important that I declare and it gets recorded, and then I recuse myself from participating from that process. That's one way of dealing with this particular, just to deal with the potential conflict, Chair. Then the second issue, Chair, around the exclusion of leaders of political parties, and I think this is a very topical issue, the sensitive one. But what we say, you know, the mere fact that you are a leader of a political party should not automatically disqualify you from submitting a tender. Now, as long as that leader of a political party is not a member of parliament or any of the provincial legislatures, even at the municipal councils. So that's what we're saying, Chair, in that regard. Therefore, that's why we're saying all these things that talk to exclusion automatically should be moved to the clause that deals with declaration, so that it gets recorded in that respect. Chair, there was also a concern about the capacity of the PPO to debar, considering that only procuring institutions would have information pertaining to transgressions committed by bidders. So now, in here, Chair, we then say we make a proposal to amend clause 16.1 to authorize procuring institutions to be the ones that take responsibility for debarment, and that the PPO should retain the register thereof. Then, Chair, I think that's we're just picking up on themes and the issues that are raised per chapter, Chair, in quite an executive summary, but there could be a number of issues. Now, chapter 4, Chair, of course, that chapter deals with the preferential procurement. Now, the stakeholders, Chair, are of the view that chapter 4 does not represent the framework envisaged in section 217 of the Constitution. And I think this particular sentiment cuts across all submissions that we receive. Some felt that the framework in its current form was unclear and vague and not implementable. There was also a view that the application of the framework is discretionary. This is very important, Chair, is discretionary in the current form, and it should not be imposed on procuring institutions to apply. While others felt that redress is a government imperative, policy objective, and therefore should be applied by all procuring institutions. In response to whether or not it is discretionary for procuring institutions to apply the framework, Parliament, of course, is entitled and required to enact legislation laying down a framework for preferential procurement policy. I mean, this is a constitutional provision, Chair. Now, the question of how tight or loose that framework is, that is how much discretion it affords to organs of state to develop their own policies or depart from the national policy, is perhaps a matter that Parliament should consider. Now, Chair, still on chapter 4, Chair, there was a sentiment by stakeholders as well that the bill can be extended to the private sector as well, and not be limited only to the public sector. Now, regarding the comment of extending the PPB, which is the bill, to the private sector by calling the public procurement bill just the procurement bill, in other words, removing that public, so as to include any other institution identified in national legislation as mentioned in section 217 of the Constitution. Now, the view of the Treasury is that reference to any other institution identified in national legislation must be read in the context of that provision. it is restricted to the same kind of genus as the list of specific words in the same phrase. And now there is they use them generis rule is relevant in this situation. In other words, the general words are restricted to matters of the same kind as those specifically listed. Therefore, the reference to any other institution identified in national legislation should be interpreted to still refer to the institutions within the public sector, as this is included in the list referring to organs of state in the national, provincial, and local spheres of government. Consequently, Chair, the bill itself, could not be changed to the procurement bill as it is concerned with procuring institutions within the public sector. That's the view, Chair, that's the proposal. And of course, it's a proposal that's open for further discussion by the committee. Now, to this end, Chair, a separate, more detailed framework has been suggested, which forms the proposed revised Chapter 4 that is attached to this presentation and should be discussed separately. So I'm not so sure if, but that's what we wanted to do, Chair, if time permits, that the Chapter 4 should be discussed separately in detail, because that framework, has been developed and in a draft format, and it is part of the documents that we sent through to Parliament. Then Chapter 5, Chair, deals with the general procurement requirements. Now, the views expressed by stakeholders on this chapter related to possible conflict and contradiction between the regulations issued by the minister and those issued by the PPO and the PTs. Now, we have made a proposal, Chair, that is to deal with this concern, and then also the issue that is raised across all submissions. We proposed at least a revision of clause 18.1 of the bill to read that the minister must prescribe a framework within which procuring institutions must implement the system referred to in Section 8.1b for a strategic approach to procurement within institutions. So that is also contained in the comment matrix, including in the report that we have. Now, we also proposed a rewording of clause 2D to read as follows: provide strategic support to the procuring institution in the performance of its procuring responsibilities. The other issue, Chair, the rewording of clause 26.1 by replacing the PPO to read as follows. So clause 26 deals with the access to procurement processes. So in other words, the public would want to sit and listen to what discussions are when evaluating or even adjudicating tenders. Now, we think that this is a very serious issue. It should not be a responsibility of the PPO, but on reflection, Chair, based on comments, of course, that this should be the minister should be the one that determines by regulation measures for the public, civil society, and the media to access procurement processes, Chair. The next issue, Chair, relates to the dispute resolution. Now, the stakeholders also raised concerns on the independence and impartiality of the tribunal in executing its intended functions. Furthermore, stakeholders questioned the value of the tribunal itself and whether or not it will have the same powers as the courts, or it will just serve as an additional red tape. Now, the main view, Chair, expressed in the chapter is that in its current form, clause 31, Chair, deals with the reconsideration of reconsideration by procuring institutions. In other words, if you've got a grievance or you are not satisfied with an outcome of a particular procurement process, then the procuring institution should be the one that deals with. Now, the view, expressed there is that clause 31 compels bidders to first approach the procuring institution and exhaust the internal process before they can approach the courts. Now, stakeholders felt that they should be allowed to approach the courts directly to accommodate cases where the bidder has no confidence in the procuring institution to objectively investigate their grievances. The reasons, Chair, which we then provided for this thing, in fact, because that section is by no means an attempt to tamper with the rights of bidders to approach courts, but the rationale is to minimize legal costs, and also considering that some sectors of the society may not necessarily have the necessary resources, financial resources, to approach courts. So this is why we have this, to minimize legal costs, and also to avoid unnecessary litigation, and of course to expedite dispute resolution that may have an impact on service delivery. Chair, we know that in this country, and it's a fact, that court processes in their very nature are long. They take very long. And we think this alternative dispute resolution mechanism will provide the necessary relief and ensure that service delivery is expedited and not impacted negatively. Now, to this end, Chair, we propose that bidders should be compelled to first exhaust internal dispute resolution mechanism to minimize, as we indicate in this, part around legal costs, etc. Chair, it's a proposal that we're proposing. Then, Chair, tip number 7 that relates to general provisions of Chapter 7. And the most consistent view, Chapter 7, Chair, deals with general provisions. Now, the most consistent view raised in this chapter was around clause 51, Chair. And clause 51 relates to the powers of the PPO to enter and search premises. Now, it should be noted, Chair, that the power conferred in the clause is for purposes of compliance and not to investigate criminal conduct. That's just the distinction that we wanted to make, Chair. Now, stakeholders, Chair, also raised concerns on the clause on limitation of liability in terms of clause 54 of the bill. Now, based on comments, Chair, that we received, and we then proposed the rewording of clause 54 to read as follows, Chair. A person who exercises a power or performs a duty in terms of this act is not liable for any loss or damage suffered or incurred by any person and shall not be subjected to any criminal prosecution. This is, Chair, based on decisions taken in good faith. That's what this clause is all about. Arising from a decision taken, of course, in good faith, Chair, in the exercise of a power or performance of duty in terms of this act. Now, in clause 57, Chair, I'm just about to finish, Chair. Clause 57 is a clause that provides for exemptions. We then propose that we remove from, I'm sorry, clause 57, Chair, deals with deviations, not exemptions. Now, we propose that we remove clauses 5(1)(c) and D. And these clauses, Chair, from clause 57 deal with disaster management act as well as the state of emergency as envisaged in section 37 of the Constitution. Now, we propose that this part 2 clauses should move to clause 56. And clause 56 deals with exemptions, because stakeholders were saying clause 56, the grounds for exemptions, do need to be revisited because they seem to be limited. Now we're adding to clause 56, we're adding C and D. So we're taking those from 57 and improving on clause 56 as grounds to justify exemption, which is also going to be approved by the minister. Now, in clause 57, again, Chair, the heading there is deviation. Now, we've also proposing that the word deviation should be replaced with the term departures. That's the first thing. The second thing, we also want to give that responsibility to the minister rather than the PPO chair. So, in a nutshell, Chair, these are the comments in general that we've attended to so far, as indicated that we couldn't complete all of them, but at least we've done a majority of them, and the issues that are coming through are almost similar, although in different contexts in the way that different stakeholders have submitted. Thank you very much, Chair. Let me end it here, and I'm not so sure, we'll be guided by the Chair on how to deal with chapter 4, which is detailed. We said at least we would want to present the chapter itself rather than the presentation. Then we can take the committee through it. Thank you very much, Chair.
Thanks, Mr. Mateo. Is it possible that you summarize chapter 4 so that it is on record that you briefed the stakeholders and the public in general of what is contained in that chapter, so that when we move to the next process in terms of processing the legislation, it should not be like it's a matter that was dealt with behind the veil. So there should be no veil of secrecy in dealing with any matter. So take us through chapter 4. It's a very crucial.
Thank you, Chair. Thank you, Chair. Yes, thank you very much, Chair. Let me just quickly take you through. Firstly, chapter 4 is, it's a preferential framework and deals with preferential procurement and the procurement policies. And what we say in chapter 4, a procuring institution must implement a procurement policy providing for categories of preference in the allocation of contracts and the protection or advancement of persons or categories of persons disadvantaged by unfair discrimination, as envisaged, of course, in section 212 of the Constitution, in accordance with the objects of this Act and the framework of this chapter. Now, in summary, Chair, clause 18 of the framework, the clause 17 deals with that part, which is more, which I've just alluded to. 18 refers to set-asides for preferential procurement. So that's the first part that should be known. And this procuring institutions may set aside a bid for a category of persons provided for in subsection 3 in accordance with the prescribed thresholds and conditions. So in subsection 3, there is a list of what the categories of persons are. These are small enterprises owned by Black people, by Black women, by women in general, by Black people with disabilities, by people with disabilities, and by Black people who are youth, and by youth in general, as well as you know, enterprises located in a particular geographical area. So that's what this particular clause provides. Now, clause 19 thereof, Chair, regulates the pre-qualification criteria for preferential procurement. It reads as follows: a procuring institution must, in accordance with the prescribed thresholds and conditions, apply pre-qualification criteria to promote preferences in the allocation of contracts by advertising a bid with a specific bid condition that only one of the following bidders, one or more of the following bidders may respond, one or more of the following. Then it says, number one, a bidder having a stipulated minimum triple B status level of contributor. Number two, a small enterprise. C, a bidder subcontracting a prescribed minimum percentage, of course, to the small enterprises that are at least 51% owned by Black people.
Chair.
Yeah.
Chair.
Noxen.
What document is Mr. Matebula talking to? Because the presentation as it is not moving. I'm not sure whether the chapter 4 note that he's giving us is not necessarily ready, that it is not showing on the screen. Just for clarity, Chair.
Okay, Mr. Matebula, is it possible that you can screen chapter 4?
It's actually in the attachments, Chair.
It's in the attachment.
Yeah,
Okay.
I'm just gonna share it, Chair.
It's already there.
Oh, it's already there. Okay.
Have stakeholders received chapter 4?
Yes, that's fine. There is chapter 4, Chair. That's a document that I'm reading from. I'm sorry that but it's not moving now. Why is it not moving? It should be moving.
What is the problem from your side?
Okay. Just check. It's not moving from my side, Chair.
Buhle ukhona?
But that's a document that I'm referring to.
Kwenzakala yini? That document is not diving here. What's the problem?
Chair, I've made MP van Schoor co-host. I think she's projecting. If she can just let me know if she's having issues, then I can maybe project from my side.
Okay.
From their
Yeah,
side.
Chairperson.
Honorable-
Chair.
Yes,
I was going to propose, Chair, that we adopt the request or proposal by the officials of Treasury. Having read everything that was sent and attached, I agree with him that that chapter 4 is too involved. It is a presentation on its own. And the reason we're having this challenge now is because we are forcing a Word document, a PDF Word document, to be screened and all of that. And now you must go line by line and read a font 11. It's just too cumbersome. If you had prepared to do this, you'd have done a PowerPoint. And because they have thought it through and they know that that is the crux of this bill, they are proposing that let's give it the necessary attention it deserves. So, and maybe when the PowerPoint was not moving, I actually thought Mr. Matebula is just going through the high level, which he should do, because now if he does this, then we must write off the whole day. I'm ready for it, by the way, on my side. Then we can write off the whole day, Chair. That thing is very meticulous. We need to look at it the way that is proposing. So Chair, I also appreciate your guidance to say you must take us through. But now, if you force him to bring it on screen and read line by line, it defeats the whole purpose of his proposal. So I suggest that we look into the proposal that is making and not force him to do what we're doing now, to get him to read a font 11 on the screen. Just maybe allow him to just talk to it, even if, because we're not going to engage with it extensively today if the proposal is accepted. Yeah, so Chair, I think that's what I'm proposing, that let's adopt what he's suggesting. We'll note that there is an outstanding matter of that. Maybe we can agree that next week we can then deal with it specifically, and then we can then say we've processed this bill properly. Thank you, Chair.
Thanks, Honorable Moy. Honorable Maswan.
No, thank you, Chair. I've got just a slight difference with what Honorable Manye is saying. If it were only ourselves, I would agree. But because there are stakeholders who are part of this session, who themselves have made presentations, it is in their interest to hear what Treasury has said, even in respect of clauses that were all belonging to Chapter 4. So in essence, it wouldn't be complete if the department were not to go through that. And thereafter, I'm sure in terms of agenda, there would have been opportunity for comments from the stakeholders, and then the process is back to us. It's only that difference I have slightly, Chair, and I think I was under the impression that Treasury would speak to the amendments that they've so proposed in respect of Chapter 4, which is a separate document they've prepared. I think they must speak to it. Thank you.
Thanks, Honorable Maswale. If you don't have PowerPoint presentation, Mr. Mateo, just speak to the chapter. As you said, we have received the presentation on Chapter 4, so that the stakeholders that are here in the platform and the public in general, because this is a public meeting, it's not a meeting held in committee, it's not an in-committee meeting. Even members of the public are supposed to benefit from what we're discussing now. For instance, I think probably the parliamentary TV is capturing this, or any other live streaming platform that we have. So it's a very crucial chapter. Find a way of speaking to it. I understand the issues that Honorable Manye was raising. Being a communicator himself, he has got a better understanding of what he was raising. But what Honorable Maswale is raising is very, very crucial. So it should be on record that on this day, Treasury responded on issues raised by stakeholders and committee members. Therefore, these are the proposals that it is bringing to the fore, so that by the time we go to the committee meeting, the next committee meeting, stakeholders will not be part of that meeting. It should not be that we are going to adopt a Chapter 4 or other clauses that were not dealt with when we were meeting with the stakeholders. It will not be correct. So find a way of summarizing Chapter 4 without going in detail, clause by clause. Thanks. I hope Mhlekazi, you are covered, Honorable Manye.
Yeah.
I'm defeated, Chair.
Asifuna ukudefeat abantu lapha, we must discuss as colleagues. We don't want to find that other members are not compatible with the process of how we are run the meeting.
In that case, Chair, can I perhaps rephrase what I was saying, but it's clear. Firstly, I'm saying, Chair, that National Treasury is not against, and I'm not speaking for National Treasury, but my understanding of what they're saying, they actually want to do a quality job. This is what they want to do. And they are saying that because Chapter 4 is so involved, they are proposing that, this is their proposal, they are proposing that let's bifurcate this presentation. Now, when you bifurcate the presentation, unless we are rigid here that this date, because it was convened in heaven, we have to do everything on this particular date. They are proposing that let's see this date as part A of the work that needs to be done, and part B of this very date be dealt with at another time, so that quality discussions and presentations can be made on Chapter 4. This is what they are saying, Chair, which I agree with them. Because if we then are going to look at that this meeting is scheduled to finish at 12, as an example, and then you want them to go to the level of detail that is required to give justice to Chapter 4, we are not going to finish at 12. So in consideration of that, Honorable Maswale, they are not saying they don't want to talk to it. They are just saying it's too involved, and 9 to 12 is not going to be enough to do justice to it. And they're proposing that we do everything else, and then this one, we have a specific day. We can bring the stakeholders on that day as well, Chairperson. It doesn't mean that on day 2, we don't have stakeholders. They can also be invited similarly, so that this thing can be given justice. I think this is my understanding of what is being proposed, which I agree with. Now we are forcing them to blow up a font 10 to a font 20 and go line by line. And they are not prepared for this, Chair. That's why I don't have a PowerPoint. And now they're going to read the PDF because the committee is forcing them to do so. Yeah, Chair. So that's really the issue, Chair. But I will take guidance from the Chair. Thank you.
Thanks, Honorable Manya. We have got parliamentary processes that we have to adhere to, and they are prescribed in terms of the rules and procedures of Parliament. Now we are at the stage where National Treasury is responding to the issues that were raised by stakeholders and the committee in the last meeting. And this is the right platform where they have to cover all those issues raised by stakeholders. Hence, we requested that they should distribute their response to stakeholders and members even before we come to this meeting. So I take it that all of us have read this document. It's just that Treasury officials are presenting. But if we have read, it means we understand what is contained in this document, including Chapter 4. So I will request that we allow Mr. Matebula to take us through Chapter 4 without going into details, because we take it that we have read the document and summarize, then we take it from there, allow stakeholders to comment and members, then we agree on the next step of processing the bill. Thanks very much, Honorable Manya and Honorable
Covered, Chair, covered.
Okay, enkosi Mhlela. Tatan Matebula, please proceed and take us through Chapter 4 without going into the clause. Because the member will deal with clause by clause in the next meeting of the committee, and you will be there in that meeting. Thank you.
Thank you very much, Chair. Thanks. Let me just try to summarize without going into details. Maybe start from where I ended. So the next issue, Chair, is which is provided for is the preference point systems. Now, Chair, here we're giving at least a variety of menus. You know, there is a 90-10, and 90 points, 80 points, 70 points, as well as 60 points. So from the previous, or from the current PPFA, at least the extended is a variety of menu in terms of the preference point system. That's what is here as well. There's also a clause on subcontracting as a condition, Chair. It's also provided in here in chapter 4. And we detail also that those particular issues, Chair, and how they should be applied, etc. The one other issue, Chair, the clause 22 is the designations of sectors for local production and content. And, and this is the power, Chair, that we want to confer to, of course, to the relevant minister in together with the Minister of Finance, at least, to deal with this particular issue. So that is also contained in chapter 4, and there are details thereof, Chair. The next other item here on clause 23 is about measures to advance sustainable development. It's also provided for, and also contracting conditions in this chapter. And lastly, Chair, there are measures for beneficiation and innovation, advancing creation of jobs, intensification of labor absorption, and development of small enterprises within particular geographical areas, Chair. That's the last part of what is contained here, Chair, without going into details. And then, of course, we have the definitions that we also proposing that they should form part of chapter 4. That takes us to the end, Chair, of chapter 4. And thank you very much, Chair. Back to you.
Thanks very much, Mr. Matebula, and your colleagues from National Treasury. Has the DG joined the meeting?
Thank you, Honorable Chair. Not yet. I'll check, but he's not joined us. Thank you.
He's not here yet, Chair, but we can always check with him, Chair. Thank you. Let's just check.
Yeah, just check with him if he can be available before we close the meeting, so that we move at the same wavelength with him as an accounting officer as to how do we move forward. Thanks very much, Team Treasurer. Now we are at item 3, comments by participants. Saika, Alan, you said they have apologized. So it means we'll start with Atasa. Each stakeholder is given 2 minutes. Please time yourself and concentrate on critical issues that you want to raise, so that you should not feel prejudiced when I say that your time is over and think that we are bulldozing you. Please concentrate on key critical issues that you want to raise within those 2 minutes. And as I've said, I don't want to be seen like being rude and stop you when you are presenting, because you would have exhausted your 2 minutes. Let's start with Atasa. It's 4 minutes past 10. So 6 minutes or 7 minutes past 10, because you have already taken some of your seconds. You should be done. Over to you.
Chair, I don't think they're on the platform.
Alan, are they not in the platform?
It doesn't look like they're on the platform, Chair.
Okay. In case they come, we'll accommodate them towards the end. RSA cluster group. RSA cluster group.
Chair, there's a Steve Jardine, if he can just unmute himself.
Steve, are you there? It's like he is unmuted, but I can't hear the sound. RS8 cluster. Steve, can you hear us? Okay. Let's ask Steve. We'll come back to him. Anna Lashmia.
Hello, Honorable Chair. Hello, everyone. Good morning. Thank you very much for this opportunity. Thank you for the revision done so far to the bill, which I think very much going towards the right direction. Just a couple of comments. I've read the draft chapter 4. I'm very pleased to see that there is now explicit reference just to preference given to women. So I think we're going towards the right direction. Just a couple of comments that I think is a bit of a shame not to have seen in section 25 when there is mention to the use of technology, not specific reference to the possibility to collect gender disaggregating data. This is an opportunity that I think should not be missed, and I think the bill should make reference to it. For the dispute resolution concerning the composition of the tribunal, I think it's important that the bill gives out the signal that the tribunal has to be representative of society and therefore has to be diverse. And these are the two issues that I don't see, at least at the moment. I don't know if there is any plan to address, but I thought it's a bit of a shame not to have seen in this revised draft. And then when it comes to the due diligence, I made a comment that I thought it would have been good to make reference to violence against women as a cause for exclusion. I don't see, I haven't had much time to look through the revision of the proposed amendment, but I don't think I've seen anything on that. And this is all I wanted to say, just wondering if the committee has got any plans to make those amendments, if there will be further opportunity to revise, and if this issue will be considered. Thank you very much, honorable members of the committee. This is all from me.
Okay, thanks, Madam Anna Lachimia, for your input. Let's move to Mining Equipment Manufacturers of South Africa, MEMSA.
Chair, sorry to interject. I've spoken with Steve. He is back on the platform, so if we can just give him a chance before MEMSA.
Okay, Steve, are you there? Hello, Steve. I can see his mic is unmuted, but I can't hear the sound.
Chair, maybe if we can just ask him to leave the platform and log back in, hopefully that will work.
Okay, let's proceed and we'll keep on checking with him what is the problem with his mic. MEMSA?
Good morning, Chair, and thank you very much for the opportunity. It's Elizabeth Jansen van Vuren, and I'm standing in for our CEO who is at a medical appointment. Apologies for that. We would like to sincerely thank the Parliamentary Committee and Treasury for the extensive work that has been done in reviewing the submissions and making proposed changes to the bill and to Chapter 4. Due to time constraints for response, we may want to follow up with a written response, but we will do our best for now. With respect to the redrafted Chapter 4, which is for us of key concern, we strongly support and would like to thank all of those involved for the inclusion now of designation, local content designation as an instrument of preferential procurement. We believe that will make a huge positive impact to local manufacturing and thereby employment. We have a few small questions and concerns with respect. We note that there is no measure in currently, or maybe we missed it, but there doesn't seem to be a measure to keep in place existing designations made under the triple PFA. We'd like to bring to your attention that those designations took, in some cases, years to put in place. And if they are now simply zeroed, those very same industries will lose such market share. They may not at a later point be able to catch up and provide what is needed to provide. So could we please look at providing to keep those in place? They also impact not only on the manufacturers, but the entire supply chain, because everything is interconnected. Secondly, it's noted that the minimum required number of local manufacturers is 3. We would like to propose that in special cases, 2 local manufacturers may be sufficient, understanding that for some specialized categories of equipment, the local market would actually only sustain 2 such manufacturers without designation. And it is designation in itself that will create the conditions for more local manufacturers to arise. The case in point is, for example, some of the yellow metal equipment. We've been through a long process to get that designated with 2 local manufacturers. That designation is in its final stages, with masses of research behind it. Once that is in place, some of our manufacturers, for example, of underground mining machinery, which is very similar to the yellow metals, could step into the space. And at that very point, there would be more local manufacturers. Such a designation is always subject to review, and if it is found that it is leading to some kind of monopoly situation, could be withdrawn. So we would like to please keep that door open, especially in specialized type of situations, industries. Just in terms of wording, there is some wording in text, again in clause 22, around locally produced services or goods or locally manufactured goods. We're not clear what is the difference between locally produced goods and locally manufactured goods. If locally produced goods simply means repackaged or the like, we would not be very happy with that. So we just need that clarified. Then clause 19, just going beyond clause 22, just rushing through for the sake of time. On clause 19, on the pre-qualification criteria where one or more has to be applied, one of them is subcontracting to a minimum percentage of the contract to a small enterprise, which then has to have a specified ownership structure. And according to what we read, only one category may be selected. So, for example, we feel this leaves the room open for convoluted and strange and possibly unfair procurement processes. So, for example, a bid condition could be that 20% must be subcontracted to an SME owned by military veterans. And in that case, an SME owned by disabled people is necessarily excluded. We're a bit concerned about that. Lastly, in Chapter 6, as per the presentation earlier today, the proposal is to compel aggrieved parties to exhaust internal processes before...
Hello.
Sorry.
Elizabeth, I hope you keep to your time. You know, more especially when women are in the platform.
I'm on my last sentence, Chair.
Yeah, so that I should not...
Chair, we're on the last sentence.
Yeah, please do so.
I'm on the last sentence. Thank you. The proposal is to compel aggrieved parties to exhaust internal processes with the aim to expedite the process. We just note that sometimes internal processes themselves can take very, very long and or be subject to corruption. And there needs to be a very clear and fair indication of what is meant by exhausting internal processes with time limits so that these in themselves are not allowed to drag on. Thank you very much, Chair.
Okay, thank you, Elizabeth from MEMSA. Wikona, are you there?
Good morning, Chair. I think from our end, we wish to thank the committee and yourselves. However, I have not been given, more information or inputs from the co-chairs, who one of them was invited to participate. However, we will share more inputs after we've consulted with them. Thank you, Chair.
Okay, thanks, Mahadi, for that. We'll hear from you. And then let's move to Joint Strategic Resource, JSR. Over to you, 2 minutes. JSR, are you there? Are they in the platform, Anna?
It doesn't look like they're on the platform, Chair, but Steve's logged back in. If he fails to talk, there is a Stephen Woodall from or representing Steve as well. So if Steve can't, then maybe Stephen can come in.
Hi, good afternoon, Chair. Can you hear me?
Yes, we can hear you.
Oh, brilliant. Thank you very much for the opportunity to be here. I did miss a few of what points Memza was making, but I think it's absolutely essential from a manufacturing point of view is that we keep a very, very good grasp on what the issues are in our procurement to ensure that we always get good technical and quality outcomes in the technical purchasing preliminary. There are a lot of other smaller procurements which will have different processes, and I think I'm interested with the announcement that there's going to be a number of other different evaluations. So the 60-40 all the way up to a 90-10. And I think all of those are going to be quite interesting, and I think the devil's going to be in the details. So I do think that it's worthwhile mentioning is that we've got to try and keep things as simple as what we can, rather than complicate them overly. And I'm very, very aware of some of the comments that were made earlier, which is about the culture and all of these things that we're talking about. But ultimately, we're talking about a contract, rands and cents. And I think that, we can come up with a mechanism that is going to enable us, without getting into complex details, that we confuse ourselves just simply because of the rules. So I think one of the recommendations that we certainly would like to make, and that is that when we're evaluating, we think that there's probably going to be an opportunity for us to look at some other way in terms of how we maybe do some of these calculations. And taking the profit portion out of your local discussions or even in some of your procurement discussions, what it means is that we start looking at very real value add rather than just what somebody might be adding in, and it might be exorbitant, it might not be. And by taking that factor out, it gives us the ability to go back to basics and to have that discussion, focusing on the value add portions and making sure that we're able to fully get into what is needed for that particular purchase. I think the opportunity that we also need to look at is that when we start looking at your socio-economic reference that was given right at the very, very beginning of chapter 4, I think the wording is potentially very good, but at the same time, it can be very bad. So I think that in everything, once again, this is one of those conflicts, but I think we need to keep an eye on things and make sure that we don't actually get ourselves into trouble. So number one is that around socio-economic, we would think that by developing businesses and all kinds of businesses, not any preferences, and just making sure that South Africa is competitive, then that would be a socio-economic outcome that we need to actually give some preference to. And what we can't do is we can't load pricing because of previous disadvantage. It doesn't work. In many instances, we are selling into global environments where we have global competition, but yet we don't understand how we actually keep our and constrain our companies when we actually have all of these hurdles that they have to actually meet, despite the competitive markets that they serve in. So I think we need to think about that quite a lot more in the way that we approach things. And the assessment has to be around quality and price. Performance is going to be a key issue in some instances. And if there is an incredibly important piece of equipment, for argument's sake, that is maybe not as cheap as some of the other things that we get, sometimes we find that the competition coming in from countries like China, for instance, is not always competitive. And how do we actually deal with that? So we need to have provisions that actually allow us to have some kind of discussion around moving towards this performance of a particular machine or a particular procurement that's needed. So I think that needs to be beefed up. What I do think needs to be beefed up as well is that the process at the moment is totally disabled. There are all kinds of deviations outside of the system, and we've got to make sure that we don't actually get back into that kind of scenario. And we need to try and look for opportunities where we get maybe an alternate to the CSD, which actually gives us good information that we can actually do an evaluation up front of what kind of companies are actually out there, what kind of suppliers there are, and we get industry to do self-evaluation of the suppliers that are in the pool, and that we're not ending up with the buying community having to actually pick from a whole lot of people who don't actually make any sense to them. And I think last point is supplier development becomes absolutely vital. I can see it in your reference in order to try and drive that the big companies use more smaller suppliers. But I think we need to actually target why we're actually making certain provisions, because if we don't do that, what happens is people miss the boat in terms of the kind of signal that we're trying to send. But supplier development in state-owned companies is equally as important. So we can easily give work to people, but if they can't do the job, it doesn't work. We have to make sure that this whole quality cycle works. Thank you.
Okay. Thank you, Steve. Sanele Komo. Sanele Komo, over to you. Alan, is Sanele?
Morning, Chair.
Molweni.
Molweni, Chair. Siyabulela. This is Advocate Nsaluba, the colleague to Sanele. I just want to indicate, Chair, that we want to thank Parliament for this opportunity, and also to Treasury. We are really indebted in the approach that they have adopted to come back to us. However, Chair, we want to say that we would want to have time to dissect the information provided, so that then we come back with an educated opinion. Suffice to say, Chair, one is a bit worried in chapter 4, in the section where we're talking about is 3A, read together with the section that deals with pre-qualification. So if we are subjecting the military veterans now who exist because of the legislation to 2 or more in the pre-qualification, and they don't exist in the earlier section on what must define the non-negotiables, I find that problematic. Because if one looks at the Military Veterans Act, it is not a may that they must be considered, it is a must. So I would want to urge that they be moved in the designated groups as they're supposed to be. The second one, Chair, just in brief, is the one that is dealing with, it's quite humbling that Treasury has dealt with the tactical issues that were going to be regulated that belong somewhere. We want to engage and see that we actually remove tactical, we leave strategic, and we make sure that strategic is monitored. There was a part that we indicated that it does not also assist us if you are having a capability that belongs to more than 3 ministries in terms of the constitutional arrangements, that you say you will choose one. All of them must be consulted in that regulation to make sure that we close the unnecessary gaps. One example being what was done in the Military Veterans Act regarding the various provisions that are across various sectors. Lastly, Chair, there's a part that deals with ICT systems. I'm not hearing anything that has been done with that, because I'm worried, because it deals with sensitive issues around hosting, which the ECT Act read together with POPIA, which triangulates with GDPR, makes strict requirements. So I would want to see what we have done with that section, because it talks about how our system currently is actually utilized as the one-stop shop, and then it observes the data privacy requirements emanating from the various multilateral agreements and legal instruments, both domestically and regionally. So, like I said, we will provide an educated opinion more than this, but we would want to request for some time, given that we got this yesterday. Thank you, Chair, and thank you one, thank you all.
Enkosi Advocate. And let's move to Ronnie Watermeyer has apologized, isn't it, Alan?
That's correct, Chair.
Okay, then Public Affairs Research Institute has also apologized, Pari.
Yes, they've also apologized, Chair.
Okay, then let's invite Steel and Engineering Industries Federation of South Africa, SAFSA. Over to you. SAFSA. Doing the platform.
There was a representative earlier, but it doesn't look like they're online anymore, Chair.
Okay, let's park them. We'll come to them later when they rejoin. The next one is Madam Conway.
Thanks very much, Chair. I'm here. I can go ahead for my 2 minutes.
Yes, over to you.
Okay. Good morning, everyone. Thank you very much for the opportunity. My comments are brief. The first one is that we'd like to thank National Treasury for considering the comments that we've put in. However, under Chapter 4, that's the first one, there's an issue of the set-aside, which refers to that the state organ may do a set-aside, and there might be a concern that some might do it, some might not. It would have been nice if it was a must. But the critical one is functionality. I've seen that functionality came back, but on the previous legislation, we had a clause that sort of protected us, because we know some of these state organs, they use the functionality for gatekeeping. And in the previous ones, there was a clause that says the functionality must not be too low, that it must not be too high, that is unreasonable, restrictive. And we have seen it a lot that in the previous bids that were out, functionality was used because it's the one that is used being responsive and non-responsive. So you don't even go over to price and other things. So if functionality can be defined and managed, or even bring back that clause, because that clause assisted in protecting the abuse of functionality as a gatekeeping tool for service providers. And the other comment is on the complementary goals. We've seen that there's complementary goals that have been introduced, and the percentages have been increased from 90-10, 80-20, now we've got 60-40 up to 70-30. But now there's the term that has been introduced, which is complementary goals, but which were sort of unclear in terms of how one determine those goals. Because on the first subset, if for 90-10, for example, it's clear that the preferentials are for BEE. Don't want to assume that the complementary goals, because they don't include BEE, which means the state organs can use those and use the ownership and all other elements that will advance transformation. And we welcome the definition of transformation and the redefinition of value for money. Thank you very much, Chair, for your time.
Enkosi Mhlekazi Madam Conway. SCO, South African Proprietary Limited.
It doesn't seem like they're on the platform, Chair.
Okay, we'll come back to them if they join, because we don't want to leave stakeholders that were there during the time of submissions. Let's hope they come to the meeting before we adjourn. COSATU.
Thanks, Chair. This is Simon Eppel from COSATU. I'm joined in the meeting by my comrade Matthew Parks. Greeting Honourable Chair, Honourable members, members from the broader constituency, and thanks to the colleagues from National Treasury. Chair, we've done the 100-meter sprint analysis since we received the document last night. We've got our running shoes on to make 2 minutes. Just to say it's too little time to make meaningful comments. We will provide written comments next week. Chair, worth noting that only roughly 20% of stakeholder comments have been considered so far, and that does raise a bit of a concern about the integrity of the process and the extent to which stakeholder participation has been considered. Chair, we notice in clause 22, the now local content designation has been added, and that must be welcomed. Thank you to both the committee and Treasury. Except that there's a challenge, and that is it's still not a pre-qualification criterion. And so it's not clear to us how this actually will work in practice because there's no mention of it in the section above on pre-qualification. We want to just emphasize it must be a pre-qualification criterion. We want to emphasize it must apply to all procurement methods and contracts. And we want to just support MIMS's insights that in some instances, it actually may be useful to have designation even when you have fewer than 3 competitors in a market. I mean, the big ticket one here is we would not have been able to have any vaccine development in the country because we only had 1 manufacturer under these rules. So quite clearly, while the intention is clear about competition, etc., practically there are instances where it doesn't work. It also would prevent us from choosing national champions, building businesses, etc. So that needs to be rethought. Chair, on the question of political interference, you'll remember from our presentation, we were concerned about it. We are concerned that some of the changes by Treasury have watered that down. So firstly, we are concerned by the removal of political leaders and family members as excluded persons in the manner they were before. Secondly, we notice that some of the protections against political interference seem to have been undermined. So I point to clause 14, which no longer gives officials the power not to comply with directions that are inconsistent in the Act. In other words, it doesn't appear to empower them to refuse instructions which are inconsistent. The third, there's still no national disclosure mechanism in the bill to nationally disclose excluded persons, their interests and their engagements in the tender market. That still devolves to public procurement institutions individually. That will be a nightmare. It undermines transparency. Chair, we note there's still no whistleblower provisions, particularly incentives in the bill, and that's a challenge. The last 2 matters, Chair, before I wrap up, and we will elaborate in our written comments, but there is still some confusion around where the responsibility of the development of procurement policy lies. There have been changes in this draft, but there is still some confusion around language. Lastly, we are concerned that some of the new changes are weakening the centralized powers of the Public Procurement Office to intervene, review, and overturn bad tenders. And we're also concerned around the allocation of debarment powers. Those have now been decentralized instead of centralized, and we view that as a major problem. Thank you very much, Chair. I hope that's been my 2 minutes.
Okay, thanks, Simon, for making an input on behalf of COSATU. Now,
Chair Barry from Nehao indicated that Mr. Eppel will respond on behalf of Nehao and COSATU. So Nehao is covered.
Okay, thanks. National Research Foundation, NRF.
Thank you, Chair. Ron Grace, can you hear me?
Yes, we can hear you.
Yeah, very briefly. We believe that National Treasury have not received our submission from Parliament. They've excluded it from what has been provided. They've only given the parliamentary content, whereas our 60-page content didn't just focus on that. And with the consent of Parliament, we went beyond what was in the narrow focus of the presentation with appropriate extensions. Secondly, we believe a few hours to consider what National Treasury has responded to generally is inadequate. We go on to high-level comments, which we believe National Treasury have not addressed, and we are just cherry-picking some from memory, and we'll request another 2 minutes later because we need to just highlight some of those. The first one is about innovation. We strongly believe that innovation needs to be...
Robert, let me understand you. You say you want to come later. You want to make an input now and come later, so that if you want to come later, we park you and you prepare yourself, and we call other stakeholders that will come towards the end.
Sorry, Chair, we're asking for 2 minutes now and 2 minutes later. We're just asking because our comments were not considered by National Treasury.
Okay, let's park you. You'll come back later and prepare.
Okay, I'll just leave for 2 minutes, Chair, and then we'll have the other two later.
Yeah, let's give another stakeholder, and you organize yourself, then you will come.
Chair, sorry, okay, Chair, are you going to give me 4 minutes later then?
We'll negotiate. Let's organize yourself.
Chair, just to save time, can I suggest I just finish my 2 minutes? I've got 1 minute and 50 seconds left. And then if you want to give me more, please do so. Chair, can I continue, please?
No, what we're saying is that because you said you still haven't done thorough work in terms of going through the document of Treasury,
Chair,
want to come towards the end.
No, Chair, Chair, I'm not saying it. I'm saying that we have done enough work for 2 minutes. We need additional time to do more work for an additional 2 minutes, Chair.
Oh, so you want to suggest that you want 4 minutes instead of 2 minutes?
I just want to give 2 now and then do more preparation and then do 2 more later, Chair.
Use your 2 minutes. Let me give you 2 minutes, okay?
Okay.
Because I've disrupted you. So thanks. Take the 2 minutes to make the presentation.
So, Chair, what we are saying in the parliamentary presentation, we said we suggested innovation be elevated to a preference category that has been ignored in the high-level presentation of National Treasury in their high-level summary. This is a high-level recommendation that shouldn't be ignored. Secondly, in the scope of what constitutes procurement, National Treasury did not highlight that there is at least one recommendation, namely from ourselves, that asset management and contract management be excluded from the scope, failing which they be changed in light of international practices. Thirdly, National Treasury ignored a major section we had on checks and balances. That National Treasury, there are so many conflicts. We gave a number of substantial recommendations on National Treasury's on the need to have checks and balances, and it's self-serving not to highlight that. The next item is critical definitions are missing. They said in their high level that there were certain definitions needed to change. We agree, and there are more that need to be changed, but certain critical definitions are missing. For example, definition of innovation, the 52171 principles. If they're going to include economy, efficiency, and effectiveness, those need to be properly defined. Then some definitions are horribly defective. For example, on strategic procurement, their definition is fundamentally flawed and out of line with a normal academic or international practice. It needs to, at minimum, be what is in line with a standard definition. The standstill period is going to hold back procurement. And we've recommended that they look at the Kenya model That hasn't been addressed. It's a major, major issue. And then emergencies. We suggested it be removed in line with the China. They haven't done so. Deviations, we suggested be done by the appropriate organ of state. They've just changed it into departure still giving and making it possibly even worse with their new proposal. Going forward, we formally propose that National Treasury formally acknowledge receipt of our written 60-page presentation. Secondly, we request National Treasury to formally respond to each of the points we've made, as we were led to believe at the beginning of this process. Thirdly, we ask the right to respond to National Treasury comments and to provide same to Parliament. Fourthly, we ask for process clarification. We've been hearing about the opportunity to be able to provide written submissions later. We would like that to be clarified. And secondly, Chair, I've just had a brief period to try and squeeze into 2 minutes. I would request further high-level points to be made later on in a 2-minute session. Thank you, Chair.
Thank you, NRF. And let's move to Amabungan. Amabungan, over to you.
Yes, thank you very much, Chair, and thank you to you, Honourable Chair, and Honourable Members for this opportunity to make this short presentation. At the outset, I would like to echo my colleague from COSATU's comments about the concerns around having only 2 minutes to respond and having received the documents last night and the difficulties that that places on us to respond in a meaningful way. And I would like to echo his suggestion, as well as the previous speaker, about being afforded the opportunity to respond with written responses so that we are able to examine the Treasury's proposal as well as analyse how our submissions have been incorporated. Be that as it may, what I would also like to acknowledge is that we are appreciative that our submissions have been considered and they are set out in detail in the Treasury's response documents, but that we understand that many of our other colleagues in the sphere and other stakeholders have not had their comments considered, and that it appears that only around 20% of submissions have been considered, and that this does raise concerns around whether the process around public participation has been meaningfully followed, and what this means for the passage of this bill if it is to go through. On more substantive questions, we recognise that our concern about having a lot of the information set up through regulation and instruction note has been partially considered by Treasury, and in their response they note that in response to our concern about the ability for public to participate in the drafting of those regulations, that they set out various transparency measures and processes that will be followed, but that this does not seem to be enshrined in the bill, and we appreciate the recognition that there needs to be full transparency around the development of those regulations, but believe it does need to be included as formally in the bill. And then just again to echo comments made by previous speakers, it is concerning that where we highlighted weaknesses in integrity and transparency in the bill and made proposals on how to strengthen that, it appears that that has been weakened, particularly around the automatically excluded people and other aspects around ensuring that the system is strongly able to respond to anti-corruption. Thank you, Chair. I think that is my time.
Thanks, Caroline from Amabungan, for your input. Corruption Watch.
Thank you, Chair, for the opportunity to engage. We'd also like to note what has been said by previous speakers around the fact that we have not had sufficient time to really engage with National Treasury's proposals and responses to us. And we would like to kindly request an opportunity to make a written submission again to the Standing Committee on Finance, one thing that we wanted to note is that we have concerns around, again, the centralization of power to National Treasury. We note that this creates a gap for maintaining effective checks and balances. And we note that this is a cause for concern for us, namely around the positioning of the Public Procurement Office within National Treasury, as this affects its independence and ability to actually perform impartial oversight, which we'd hoped would be located outside of National Treasury. And so that still remains a big concern big cause for concern for us. Another thing is the dispute resolution mechanisms. We think that those should still be tightened up, as well as per our submission, and those that have been made by others. We note that there were 112 submissions that were made, and we note that National Treasury had said that due to time, they had not been able to go over the rest. So we just wanted clarity around what would be the process going forward as to whether they will engage with the rest of the submissions made. And then lastly, in terms of the politically exposed persons, we still maintain our call for automatic exclusion on people who are politically exposed. We have seen that not having this mechanism does nothing for transparency, for accountability, and for anti-corruption as well. And we've noted that this has not worked in the past. And so we need to make a very decisive decision around the automatic exclusions in particular. So thank you very much, Chair. I think that was within our 2 minutes. Thank you.
Okay. Thanks, Corruption Watch. South African Institute of Race Relations.
All right, thank you very much. I will echo the previous comments about a request to make written submissions next week, given the time constraints. I would like to start by noting what does not appear to be recognized, which is the connection between the existing procurement framework and state capture, as articulated by the Zondo Commission. The clear identification made in volume 1, starting around page 795, is that the kinds of preferential procurement fixated on race that exist in the system today, the ambiguities around that have already contributed to discretion, confusion, an inability to audit or account, and therefore incentivized rent seeking. That is not addressed, it's exacerbated. I note with great alarm the introduction of the 70-30 and 60-40 price compromise, increasing the premium for non-value add considerations in Chapter 4 in the proposal. It's going in exactly the wrong direction. I note furthermore that there's reference made to our submission that the Public Procurement Bill has no power to compel racial considerations in any instance of procurement. It says that such a power does exist because of the word equitable in section 217(1) of the Constitution. This is a laughable reading of equitable. It's just defined as distributive or redistributive. But if you look through the Constitution, there is reference to equitable distribution across provinces. There's nothing to do with race there. Our complaint is that non-racialism is violated, value add is violated. This is a scheme and remains a scheme to make the rich get richer of all races, while poor South Africans who depend the most on service delivery, which is compromised by these BE premiums, are left behind. And as a final note, in terms of SIRE, I see that there is still no reference to calculations about how much preferential procurement has already cost the fisc and how much it is expected to cost under this new dispensation, which renders it completely procedurally unworkable in terms of the constitutional requirements for transparency. And given that this is a Treasury Standing Committee, let me just finally note that there's no mention, even in the budget, of how much the extra BE premium amounts to, which is a violation also of 216 of the Constitution and the requirements for transparency there. Given the lack of transparency, it's no surprise how much money goes missing. Thank you.
Thanks, Gabriel, from the Institute of Race Relations. I can see that the DG has joined, but it looks like he has also apologized that he's joining another meeting at 11. Is it so, Dr. Peterson? DG, are you there? Okay.
Yes, Chair. Apologies. I am here, but because I was traveling, I'm on my phone. So I was just struggling to unmute myself. I have been following the inputs, Chair, and listening to them closely. So certainly I will pick up with the team how we take this forward. I do have one constraint, Chair, which is that I have an existing meeting for 11 a.m. this morning. So you will advise me in terms of how you want us to proceed in terms of my participation and how we take this forward. Thank you, Chair.
Okay, thanks, DG. The team treasurer will brief you about what we will have agreed upon moving forward in terms of processing the bill, in terms of the rules and procedures of Parliament. Thanks very much, DG. We acknowledge and take your apology. The next stakeholder, International Women's Forum, South Africa.
Good morning. Thank you, Honourable Chair, honourable members of the committee and National Treasury. Firstly, thank you for providing the opportunity for us to report back on the work that's been done. However, without belaboring the point, I must also support the other organizations and in particular the representatives of COSATU and Amabungani in respect of the time that's been afforded to us to consider the document and the need to make further, preferably written comments on what has been provided. So without going into too much detail, given that we've been afforded 2 minutes, our organization, the International Women's Forum of South Africa, focuses on women's involvement and particularly Black women-owned businesses. And we don't believe that our submissions have been considered in context, nor that the reasoning provided sufficiently explains how Chapter 4, Section 18 has been amended. So just looking at the reason provided where it says that the review team did not agree with the notion that the preferential procurement is discretionary, and then refers to Section 217, subsection 1 of the Constitution, already mentioning the concept of equitable. Now, in our view, this does not in any way deal with the fact that women-owned businesses, and in particular Black women-owned businesses, are not specifically included and continue to remain an option in terms of how the wording of Section 18 is currently structured. So nothing has been addressed in respect of the commitment made by President Ramaphosa in stating that government had resolved to set aside 40% of public procurement to women-owned businesses in a bid to achieve equality. As the proposed bill currently stands in terms of Section 18, women continue to remain an option, particularly where it refers to small enterprises owned by Black women. That doesn't mean that a percentage of the bids will be given to women-owned businesses or Black women-owned businesses, but they still only remain an option. And this, in our view, has completely ignored the points that were made by the IWFSA. I'll leave it at that, Honourable Chair, as I think we do require further opportunity to address, I think, the failure to give consideration to our submissions, or I suppose to fully give the required attention thereto. Thank you for this opportunity.
Thanks, International Women's Forum, South Africa. Budget Justice Coalition.
Thank you very much, Chair, for the opportunity. So as the Budget Justice Coalition and Imali Yetu, we had noted in our submission that there's a risk for the Public Procurement Office being undermined by poor provision of shared services. And furthermore, we'd also noted that the Zondo Commission had actually made recommendations around the need for independence and specialized oversight mechanisms. And unfortunately, we think just from having engaged in this presentation this morning that this is a critical part that is still missing. One. Secondly, we want to argue that regulations, again, are a big sticking point for us. We feel that a lot is still being left up to regulations, and we think that this should be found in this draft bill and that we should be engaging in this process more rigorously. The third one being that the definitions still need to be clarified. We think that currently, as it stands in the bill, there needs to be further clarity in the definitions so that there is no misinterpretation. And then lastly, Chair, around the conflicts of interest, we think that these must be dealt with quite decisively. If not, again, they will take us back to the current situation that we find ourselves in around a lack of transparency, high levels of corruption that we're faced with in South Africa. And so we think that, again, these mechanisms must be addressed, must be dealt with quite adequately in order for us to move away from the current situation that we find ourselves in. And then lastly, in closing, we would like to also, where possible, make further submissions to the committee around what we've heard from National Treasury as well. Thank you.
Thank you, Budget Justice Coalition. Black Business Council, over to you.
Good morning, Honorable Chair. Morning to honorable members. Thank you, Chair, for this opportunity. I hope I'm audible. Thank you, Chair, for this opportunity to present and respond to National Treasury. And we want to thank you in particular at National Treasury for engaging on the submissions that we've made. It gives credibility to the democratic participation. Firstly, we welcome the substantive changes that have been made on Chapter 4. They're not we're not entirely happy with it. There are certain areas that we may not be happy with, but we think it's much more progressive, and at least there is a framework, which that was the biggest issue for us, that there needs to be a framework there, and that few points that we want to raise with regards, firstly, with the complementary goals. I think if we're going to go with the new concept of complementary goals, we need to define them exactly. There should be no ambiguity about what it is, and what does it mean. And also our view would be that there is no need to introduce another terminology. Let's just keep with the preference point system. So that 30 points and 40 points should just be for preference points, so that we don't create any confusion by introducing new terminologies. The second issue is with regards to set-asides. We are particularly concerned about the may implement. I think it's very problematic. From our experiences with procuring institutions, is that where they have to, push the boundaries, they rather do, the normal, processes and not engage in activities that they are not familiar with. So they will not do it if it's an option. So we're saying it must be must. But then we understand where National Treasury is coming from. Instead of saying may, let's say must, and say where it is not feasible. So the onus would then be on the procuring institution to demonstrate that it is not feasible to do a set-aside, so that, as part of our advocacy, we can engage procuring institutions and ask them in terms of why have you not implemented set-aside. So it must be a must. And then the other issue, we still maintain that, this bill lacks the strategic intent in terms of driving the broader socio-economic objectives of the country, particularly around issues of promoting national industrialization. We got a program of Black industrialization program, just to give an example, where, a government invested a lot of money in developing Black industrialists, but when it comes to procurement, they can't get access to procurement. But also we do not see how it supports, the supply development. There was a program about, competitive supply development program of the state, the NTP, the NTP goals and all that. So we're not seeing, a government using its physical, power to actually, be strategic in the intent and drive the development and industrialization and this product social community goals. And moving fast, the other issue is we're still missing the infrastructure chapter. We still feel strong about it. We think it's very important that we have an infrastructure chapter. And again, if we're given an opportunity to make a write-up, we'll put a write-up on this. And then the other issue, the last issue, in the interest of time, the powers of the procurement officer. We think, they need to, the procurement office should be able to, to publish procurement reports, in the interest of transparency, demonstrating how much have they spent towards BE, how much have they spent towards the set aside, but also in terms of local procurement, and where they realize that, those principles are not coming up strongly in terms of procurement report, they must take measure, they must be empowered to take measure to correct the misapplication of the law. We'll be happy to make written submission if that opportunity is made, Chairperson. Thank you very much.
Thank you, Dr. Mapafa, for your input on behalf of Black Business Council. Association for the Advancement of Black Accountants of South Africa, ABASA. ABASA, are they in the platform, Alan?
It doesn't look like they're on the platform, Chair.
Okay, let's proceed to African Procurement Law Unit.
Thank you very much, Chair. This is Professor Giokina on behalf of the African Procurement Law Unit. We thank the committee for granting us this opportunity to address it on the comments we've received. We must, however, also echo the comments of many of the other stakeholders that we consider the time given since we've received the comments inadequate, and specifically with reference to these Constitutional Court judgments on public consultations in legislative processes. We do not view this as an adequate opportunity. Most recently, in relation to the Traditional Khoisan Leadership Act finding of the Constitutional Court, it is important that Parliament keep into consideration the parameters within which public consultations must take place. And we are of the view that as this has happened, it's not adequate. So we would strongly urge the committee to provide further opportunities to properly consider the feedback. Furthermore, we are extremely concerned with the fact that based on the documentation that's been provided, there's been very selective attention to only a small handful of entities' comments by National Treasury. Our comments, for example, there's been no response from National Treasury whatsoever, which raises in our minds very serious questions about whether those were even taken into account at all. Moving then swiftly on to the other main point that we want to make, Chair, and that is overall main point, and that is that in our view, there's still far too much left to regulation under this proposed bill, and we urge the committee and Parliament to seriously consider its role vis-a-vis that of the executive in the lawmaking process. We think it's simply inadequate to just allow broad delegated rulemaking powers to the executive by way of regulation, rather than putting the parameters within the actual legislation. We don't think the balance is right under this particular act. Chair, I just want to comment also on Chapter 4 broadly, and most specifically on the first 5 provisions, Section 70 to 21, which deals with the empowerment dimension of Chapter 4. And Chair, we note with great alarm that these provisions are effectively a cut and paste of the PPPFA and the 2017 preferential procurement regulations into this act. Chair, it is exactly those provisions that's led us to this law reform that we're engaging in the moment. It's the inadequacy of those rules that brought us to where we are today. And I must admit, the mind boggles that one can then simply just cut and paste those back into the act and think that it's going to be better for it. It's not, Chair. It's simply going to repeat the struggles, the challenges we've had of the last 23 years, the many court cases, which has undermined our effort to use procurement effectively for empowerment purposes. I also have serious concerns about whether Chapter 4 can be viewed as a framework. It seems to me that there are many provisions in the revised chapter 4 that can only be described as rules. Chair, it's important for the committee and for Parliament to carefully look at section 2173 of the Constitution, which only grants the power to create a framework. I think in these first 5 provisions of chapter 4, it's not a framework, it's actually a set of rules. Looking at these 5 provisions, Chair, it's simply not clear how this structure is going to work. And here I'm echoing the comments by Kusatu, how these different mechanisms that's put forward here will work in combination. For example, Section 18 deals with set-asides. Entities may set aside. Section 19 deals with pre-qualification. Entities must pre-qualify. Now, firstly, Chair, it's not clear what the difference between a set-aside and a pre-qualification in fact is. Both of them result in the reservation of a particular contract for a particular category. Section 20 deals with preferences. It's not clear whether that's a mandatory or an optional mechanism. It doesn't say whether an entity may or must apply preferences. It only tells us that it cannot do set-asides and preferences. Section 21, subcontracting, again, is a must. And then localization comes into the picture as well, as other commentators have said. It's not clear whether this will come on top of, next to. So it's just not clear what the structure and the system is that we're talking about here. Chair, the final point I'll make on chapter 4 is simply to say that it really paints us back into a corner in terms of the adjudication methodology, the formula using price as the only criterion. Chair, worldwide, it's well documented that using price to award your tenders is a very bad idea. It does not result in value for money. We need to have a broader concept of what the criteria may be. And Chair, I will finish my time by urging the committee to allow stakeholders a more adequate opportunity to respond to the comments. Thank you very much, Chair.
Thanks, Prof, for your input. South African Black Technical and Allied Careers Organization, SABTACO.
They're not on the platform, Chair.
Okay, let's proceed. Oriza, pardon me for pronunciation.
Thank you, Jefferson. Blessed morning to members of the committee and all the stakeholders. My name is Ufunoti Korombi. I'm representing Oriza Consulting. We specialize in cyber law, ICT procurement, and cyber security. So that is the reason why we are interested in this matter, due to our experience and expertise in the public sector ICT procurement. We want to thank National Treasury for the great work that has been achieved so far and for considering some of our comments. I forgot to put a timer. We believe that there should be a second draft after our return input to ensure that there is completeness and consideration of what we will want to provide as a return contribution, because as everybody else has said, we had received documents late to have time to meaningfully engage with those. So we are requesting Honorable Chair if we can be given an opportunity to submit written input, and we are available to National Treasury for further consultation in any area of matters that we are going to be raising. We will be available to work with National Treasury. Our overall sense is that the bill does not show yet how it integrates and all bring together the fragmented regulatory framework to formulate the desired state of an integrated framework. For example, there are many, but I will just give one. I do not see how ICT household values are addressed in the bill. In terms of chapter 4, Section 19.6 read with 19.7 to ensure that this the implementation of this section is actually effective. We are proposing that the ecosystem should include obligation for enterprise development, because if we are going to just call people for tenders and they are not actually equipped and there is no program that is intending to equip them, then it remains a paper exercise at the end of the day. Section 21 in terms of subcontracting, I believe there must be subsection that deals with skills transfer. Otherwise, we just having just packaging and dropping boxes, and more so in the ICT space, because I know we are importing not everything, but over 90% of whatever we consume. So we do need to have skills transfer as part of that subcontracting, and it should be legislated. And there must be methodologies or strategies within the bill that says how is this going to be managed, and we ensure that it's not a paper exercise, but it's a reality. We are proposing to also include a subsection that will guard against granting and or provide guidelines to this effect. There is the 30% that is supposed to be set aside, and earlier there was the 40% that was mentioned. But when you consider that most of the small businesses in the ICT space are actually just resellers, that 30% actually goes out, because you need to pay whoever you're selling their products. And so we just need to make sure that the issues of granting are dealt with effectively through this bill. Section 22, in terms of the designation, I saw a may, and to me that means that it's an optional extra. It's not something that we are emphasizing on local content and localization as a priority. It's like as and when it might be that the Minister of DCTI gives a request or recommendation to the Minister of Finance, then something will happen. But I believe that there must be intentions of making sure that we develop our own local content and localization is prioritized. This is because we believe it's the section it's more counterproductive when we look at issues of developing, supporting, and growing local content and the market itself. As I said, so far we are doing a lot of inputs, so we do need to develop our own content and localize our own content and be able to balance what is imported and what is exported. The bill is still not addressing issues of innovation and development sufficiently. We will provide details in our written response in terms of how we see things happening, because we as Oriza, we have developed a system, but you are not able to bring this into government because there must be somebody calling for procurement, whatever. So there's just no support for innovation, even outside this public procurement bill. Whatever acts that exist, they do not support innovation and development the way we understand it. Generally, we do not believe that this chapter 4 and broadly the bill provides sufficient procurement in ecosystem that promotes real economic inclusion. So to enable us to move from a paper-based exercise, which adds more value, and move to a space where economic inclusion is promoted in reality. Thank you, Chair.
Thank you, Rufuno, on behalf of Oriza for your input. Group of construction and engineering companies. Over to you.
Thank you, Chair. I hope everybody can hear me. Thank you for the Chair and the committee for opening this up. Without repeating a lot of the previous comments, we have the same problem in terms of time constraints and the points emphasized by Kusatu and Amabungani. and a number of the points in terms of the African Law Union. As a infrastructure input, clearly we have issues in terms of Chapter 4. We believe there's still far too much left up to regulation. When one moves into projects of a more significant scale and size, there needs to be uniformity and predictability in the market. Our market requires a capital-intensive mechanism, and if there's no predictability, the market won't invest. And then what you'll end up having is our industry, which is already almost decimated, and is just going to further decay until we'll have foreigners building our infrastructure, and we'll have no decent local infrastructure capacity to be built. In terms of Chapter 4 clause, subsections 19, 20, and 21 they're confusing in the way they're written. The pre-qualification in terms of Section 19 talks to preference, but Section 20 is talking to preference, and it creates confusion. So we want to go and distill it, have a look at it, and we'd like to make written submission. At the moment, what we read, we believe the present drafting is inadequate to serve as a solid foundation to grow this country going forward in terms of the economics. Thank you, Chair.
Thank you, Francis, on behalf of a group of construction and engineering companies. National Strategic Plan on Gender-Based Violence and Pillar 5.
Yes, thank you, Chair, and good afternoon, colleagues. My name is Peli Sankomo. I'm a development economist and the co-chair of the NSP Pillar 5 on economic power. We just want to make several things. In fact, thank you, Chair, for the opportunity, by the way, to really indulge stakeholders into this intense public participation process. And we also think that National Treasury, can read the signs or the signal from you that you would really want to make sure that the impact of this bill really has its transformative outcome that it's intended to do. We would like to support, the submissions that have been made by several stakeholders, but we want to ground 3 or 4 points, Chair, that we feel that actually, in terms of how this bill is structured, is that it's actually not gender responsive, because it doesn't recognize the 40% set-asides that the president had announced, because we believe that as well, that the redress or economic transformation has to be driven by government. So public procurement is such an important policy lever to drive transformation in the economy, particularly with the history of economic exclusion. Secondly, we actually think that we support the notion of practice notes that are issued by National Treasury, that they said they should be subjected to public participation because they tend sometimes to be quite autocratic. We're concerned about the issue of a silence on whistleblowing, because I think, having come out of the Zondo Commission and the experience around the epidemic nature of corruption within public procurement, the silence of the bill on whistleblowing, in fact, would not encourage and will discourage. So it's a disincentive for people to actually blow the whistle. The third issue, Chair, we want to really underscore, which has been coming through, that the use of price is the only criteria to approve any business opportunity is actually fundamentally flawed, given the nature of industrial capacity. South Africa has declined to 19% of industrial capacity, meaning that we almost import so many things. So it's important that we then consider other variables, which then leads me to the next point around, we need to have a very clear distinction on the issue, and I support the point on the issue of assembling versus the manufacturing. South Africa has really become an assembling economy, and that's not sustainable. So in essence, we need to prioritize those who manufacture over those who are assembling. Obviously, the last point, Chair, we actually think that the issue of gender-based violence and femicide actually to be great, it could be actually referred to, because again, if government could actually classify as part of a set-asides, which should actually constitute a must, the clause should actually have a must instead of a may, to make it sure that, you know, women who are likely to be exposed to gender-based violence and who are willing to leave their partners, and that they are actually being afforded an opportunity. The last point, Chair, which is really overall, it's a political economic question regarding the bill, is that any public procurement policy that applies one size fits all in a context where you have such a low industrial capacity as a country is always going to be problematic, which is amongst those is the bill needs to create a space for municipalities to be able to actually be much more to undertake, you know, procurement activities within, you know, parameters of flexibility. So one size fits all. I understand what it would sometimes seek to address is to address the epidemic nature of corruption. But at the same time, if you actually create spaces for various spheres of government to allow them to procure locally, I mean, for instance, I don't understand why should, you know, a local catering company that is based in Guyana should be competing with a company that is based in Johannesburg, because the procurement system facilitates exactly that. So in essence, the local procurement policies must be used to actually build local resilient economies. And government is such a critical partner in making sure that it builds those communities, I mean, those local economies. Chair, with your permission, my colleagues from Women Economic Assembly, Ms. Mahadi, just whispered to me that she would really like to take 1 minute from my input because she has received, she has some input to make. Thank you, Chair.
Okay, Sister Pelisa Nkomo, over to you, Mahadi.
Thank you. Thank you very much, Chair. So with the Women Economic Assembly having been birthed from the NSP on GBVF Pillar 5 on economic power, we concur with what Pelisa has said with regards to the 40% procurement. We feel that it has not really, it does not come out, it is not clear. And also, it is important for us as well, from a women's economic empowerment point of view, to ensure that the bill clearly indicates, especially from previously disadvantaged people or persons, that that is made specific. And also I do not recall, Chair, seeing a mention of persons with disabilities, which is also something that we are really advocating for. However, what Pelisa has shared, the Women's Economic Assembly also concurs on that. Thank you very much.
Thank you, Mahadi, for your input. Alan, is there a stakeholder that we have got or that has joined later? They were not there when we started. Before I move to the next item on members of the committee engaging.
I don't see any, or at least the stakeholders that weren't here earlier, I don't see them on the platform, Chair.
Okay, if that's the case, honorable members, it's your opportunity now to ask clarity, seeking questions on and or make comments. Over to you, members.
Sorry, Chair. On the chat session, there's a section, there's an NRF that is requesting 2 minutes.
Okay. NRF, can you take 2 minutes? Quickly 2 minutes, please, because you spoke initially.
Thank you, Chair, and thank you for giving us an additional 2 minutes just to do additional preparation. And our contributions are, in terms of the approach, we believe there should be an enabling or catalytic approach versus a restricted or unnecessarily bureaucratic approach. Secondly, we've been hearing, and we hope this will become part of the bill, that the approach will in future be more about guidelines versus instructions, which we support. And we also support that if there is any further prescripts from a subsidiary level, that those get full public participation. Our further one is that we are concerned about the centralization drive. The powers that are given are too broad. They require parameters. The powers that are asked for require direction, namely, are they in terms of best practice, or are they there to promote ease or speed or limited cost? And then in terms of donor funding, those shouldn't be bureaucratized in whether they require compliance or not. There should be a limit, and we suggest 30%. Security vetting of bidders should be removed, unless, of course, it's limited to sensitive state security instruments, and it can be circumscribed. Price ceilings should either be removed, which is our preference, or in the very limited context where ministerial approval may be required, for example, the sale of goods made by prisoners. In that case, yes, but not a broad thing. The vague terminology throughout the Act is a problem.
30 seconds.
And as such, it should be sharpened. And then disposals. We are presupposing that procurement includes disposals, and we're saying at an Act level. It's a constitutional level. The National Treasury themselves have stated that in contradictory terms on this issue over the years, including their submissions to the State Capture Commission, where they said that the Constitution does not include disposals. That requires, in our view, a constitutional change, and we fully support that. And then, of course, we would like to see more harmonization, a more democratic means of prescripts going forward. We would like to see not just one entity, but three, in line of say, other countries like the USA. Remove things like a non-trumping clause, rather bring in a harmonization clause. And the last one is that we do not believe National Treasury always have the capacity in terms of best practices to understand what they're seeking to implement. For example, on methods and procedures, in the bullet itself, they mix up contracts and methods. And our engagement with them over the years seems that they have a very, very limited understanding of what methods are available and seek to limit us unduly. In an innovation space, we need a lot more. So going forward, Chair, we reiterate our points in our covering letter, which we hope that National Treasury will respond to, that the bill in its current form will yield more harm than good. We further believe that we will end up falling further behind developing nations and other developed nations like Kenya. And of course, we promote a greater professionalization in the legal, in the process of formulating this particular legislation. We believe it's largely amateurish and promotes best practices. Thank you for the opportunity, Chair.
Thank you, NRF. Let's now invite members of the committee. Honorable, let me check the hands. Wait. Honorable Mavileta, Honorable Maswale, Honorable Manya, Honorable De Villiers, Honorable Kasani, in that order. Yes, Honorable Mavileta.
Thank you, Chair. Thank you for the presentation. And definitely this bill will bring the definition of transformation in practice, and then we'll be able to see the economic change intended to heal the division of the past. Chapter 4. I see there where you are saying on the set aside for preferential procurement. And you are talking about small enterprises owned by Black people. Black people, well, I do understand you are referring to African colored Indians. That is right. But small enterprises owned by Black women, I've got a problem. Small enterprises owned by women. So the thing is, if it is not small, you don't consider it. Or that small enterprise, if it can grow one day and become a big enterprise, is it not going to be considered? Well, we do understand that there are small enterprises out there, but if I can just see enterprises owned by Black women, I will be happy. And when I go down there again on the cooperative, or on the subcontract, I see only on subcontracting, I see that you are saying the corporate, you do not mention women under subcontract. You are saying a cooperative which is at least 51% owned by Black people, or a small enterprise which is at least 51% owned by Black people who are, I'll talk about this one, who are military veterans. I'll start with the cooperative. As far as I know out there, most of the cooperatives are owned by women. If it can just come, it can stand out so that women out there know that they are really represented, not under that Black people. We understand what Black people means. And really, I do agree. The only time I see military veterans is here when we say small enterprises, which is at least 51% owned by Black people who are military veterans. Hey, but what if they are out there, there are military veterans who really have, enterprises? I think also, it must come out clear, small means something. Thank you, Chair.
Thanks, Mama Honorable Maswala.
No, thank you very much, Chair. It's a small one. It's been referred to by some of the stakeholders when they were commenting on the adequacy of the response. The presenter from Treasury did say that owing to time, they couldn't address all the submissions. Where 20% of those seem to have been the ones responded to according to what I heard from the meeting, it would be worrisome. I would like Treasury to clarify this matter, indicate the amount perhaps of those submissions that couldn't be brought into the net, so to be responded to, and how they hope to remedy that matter. I think it's important so that there aren't voices that are said to have been ignored, so to speak. There could be a legitimacy to that claim. I think the process ought to be as inclusive as possible. And I think clearly from some of the comments, there is an implied thing that we may need to have time to allow for some of these inputs to be made, those who received, particularly in Chapter 4 yesterday, to have a reflection that could help us feel the sense of what the stakeholder community is saying in that regard. So, Chair, just Treasury for me, if they can just clarify that point, and then the rest we'll deal with in terms of process. Thank you.
Thanks, Honorable Maswala. Honorable De Villiers.
Good morning, Chair, and good morning, members and stakeholders. Chair, I would just like to echo and second what was said now by Honorable Masuele. I think, Chair, that the whole idea of public participation is that there should be responses to all submissions, not just to some, and that all stakeholders should feel that they have a fair chance to participate and give their comments and give their submissions. Chair, is quite clear from the submissions received that Firstly, the time of sending out the information last night only, the time that stakeholders had to consider the bill, the time that they had to make submissions, and the responses received on previous submissions made are all not according to good and proper public participation standards. So, Chair, I think it is extremely important that we as a committee note these concerns from the majority of stakeholders in my mind, and that Treasury responds so that we make sure that the public participation process is followed and is a fair and transparent process. Thank you, Chair.
Thanks, Honorable de Villiers. Honorable Manya.
Yeah, thank you, Chairperson. I'm going to respond in a dual way. One, I'm going to quickly, in a second, talk to the issues around stakeholders, and then I want to address the presentation. Firstly, on the stakeholders, 3 issues. One, I really want to sincerely thank the stakeholders for making time available to come to this presentation and see how their inputs have been factored into or not. I think it's a very important thing. And I also want to underscore the fact that these are private sector people, that generally for them to be here is a salary sacrifice, is a revenue sacrifice, and all of that. And it's not that you didn't have anything better to do for you to be here. So I really want to appreciate that of all the things that you could have done today, you decided to prioritize this. I think this is very important. Number one. Number two, I want to agree with the stakeholders when they say the time given to process this and to engage is nowhere near enough. And I can hear the issues around the submissions that will be made, which is a welcome issue. But I really think that if we're serious about public participation, what the committee should do, or the process should allow, is that once those submissions are made, oral and written, there must be some kind of a round 2 of sorts where we'd say, okay, this is first time we may not have got everything right as National Treasury in terms of incorporating. This is our second attempt, having listened to your reasoned submissions, but to just say, tick a box and we've done this, I think it's shortchanging the stakeholders. Thirdly, and last point on this one, I really want to sympathize with all the women and the women organizations that took Mr. Ramaphosa seriously when he said 40% must be set aside for women. I really want to sympathize with you, because if you really know the man, you would have known that he didn't actually mean it. If he meant it, what he would have done, he would have issued a directive to National Treasury to see to it that that pronouncement sees the light of day. It becomes also unfair to National Treasury officials to expect them to respond to things that have been said in various conferences and all of that, public posturing, platitudes and all of that, and you want National Treasury officials to engage with that. I think it's unfair. What would have been fair is that if you were querying National Treasury for them not responding to a directive given to them by the president, then you'd be talking. But in this case, I think I'll use a parliamentary word and say, an unparliamentary word, and say you've been conned, as it were. So, but you've got 2024 to respond to being conned. Chairperson, if I go to the actual presentation, number one, on the issue of transformation, I note the definition, but I think the definition of that transformation has omitted something very important. And what it has omitted is the issue that deals with a demographic representation. I think you can't have transformation. You can't have what you call transformation and somehow leave out the issue that deals with a demographic representation. And therefore, I differ very strongly with the input by RRR that seems to be questioning this concept. And I want to point out to Treasury 3 sections in the Constitution to highlight the issue of representation. 3 sections in the Constitution. This is very important, so that what we say here is not just our emotion or anything, is something that is consistent with the Constitution. So I want to point out the first section, section 174, subsection 2 of the Constitution, directs that the judiciary must broadly represent the racial and gender composition of South Africa. Now, why would that be there if the issue of representativity is not captured in the Constitution? Secondly, section 193, subsection 2 of the Constitution provides that Chapter 9 institutions must be composed in the same way. You see? So the whole issue of demographic profiling is embedded in the Constitution. Lastly, section 195, subsection 1, paragraph I, Roman figure I, provides that public administration must be broadly representative of the South African people. So basically, Chairperson, I'm saying to National Treasury, they mustn't be shy when they deal with this matter, because the Constitution provides for this. And I'll deal with this thing again, Chairperson, when I deal with Chapter 4. So therefore, to close on this point, it's not enough what National Treasury has said on transformation if the issue of representativity is not part of that definition. So that's the first point. Secondly, on the issue of value for money, the issue there was not the definition. I think they've missed the point in National Treasury. The issue there about value for money is exactly the issue that the professor was articulating, that all over the world is very clear that if you use price as a major consideration, you're missing the point. And you've missed the point here because you have now done it's almost like spinning that, we've removed value for money, we've increased efficient and this and this and that, which in the nutshell, substantively, you are still saying value for money. The issue here, Chairperson, is that we are saying that value for money must be removed, just like the prof, and maybe the prof Gio, sorry, the name is complicated for me, but that prof made a very solid submission. Maybe must make that in writing, and it's when I'll be clear what is it that needs to happen. And that's the sentiment that is being carried here. Otherwise, it means we're introducing the 90-10 thing via back door if we don't deal with this value for money properly. It must be excluded from this preferential system, Chairperson. And again, I'll talk to it when I talk to to Chapter 4. And then in the bill itself, Chairperson, has got a few things that it refers them to the regulations and the submissions by stakeholders were very clear that we don't want this again, where a lot of things are referred to regulations. It's almost like postponing the issues, postponing the arguments, and you tell us that no, we're still going to have other public consultations. We're having a public consultation right now, and the public consultation is saying, ensure that we've got a comprehensive legislation that's going to deal with these things, and don't tell us that this will be sent to regulation, this will be sent to regulation, and all of that. So we want to say, Chairperson, that National Treasury must take into heart the submissions by the public. And then the clause about the disbarment, the automatic exclusion. I want to propose, Chair, that the Section 18, some of the provisions of Section 18 must come to this disbarment section, so that you don't only deal with disbarment as it was explained here, where it's limited to families and stuff and all of that. A company that is not compliant with transformation must be disbarred. by the state. This must be very clear. It must be disbarred. So the disbarment must not just be limited to the fact that I'm a politician, I can't bid for government, which is correct, that I must not bid for government if I'm part of government, as it were, etc. But that must also mean that those that don't want to embrace the issue of transformation in the country cannot do business with the state. Why is this complicated? This will also, by the way, Chair, be consistent with Section 53 of the Employment Equity Act, where if you do not comply with the law, the state has got a wherewithal not to do business with you. So it will be consistent even with some of the laws that are already in place and all of that. So we can't have a situation where you are disbarred because you are a politician, you mustn't do business. But if you are a lily white company, as it were, you are not disbarred. Must be disbarred if you don't want to transform. It must be that straightforward. So I'm saying let's include the issue of empowerment on the automatic exclusion. The next point, Chair, I want to differ vehemently with the view of National Treasury when they deal with the issue of other institutions as contemplated in Section 217, subsection 1 of the Constitution. In that section, I think National Treasury must understand the difference between the two words, or, and. You know, or means one thing and means another. In the Constitution, the word or is used as a preface, as a word preceding other institutions. So in other words, because the Constitution is a Constitution of South Africa, it's not a Constitution of public service, it's a Constitution of South Africa. It cannot be that Treasury can understand the Constitution of South Africa to be referring just to the public service and being quiet about the private sector. The submission that the National Treasury has alluded to, that has been made. In fact, I think it was made by the Black Business Council to say there must be something about the private sector here. This must not be limited to the public service. I think that that contribution is correct. Perhaps we must create a provision because we want to be efficient and all of that. Maybe we can have a discussion about what to do with that, or maybe the committee must direct that maybe there must be a different bill that deals with that. But we can't accuse the Constitution of saying that that Section 217 is only for public service. Then we must have a Constitution of the public service. But if this is a Constitution of South Africa, it must talk to everything in South Africa under the sun. Just like Chairperson, as I pass this point, when we deal with health issues, the laws that deal with health issues don't deal with public hospitals only. Even private hospitals are actually covered by the laws. So we can't have here a procurement thing that just deals only with the public service. It must also deal with the private sector. But if we have to have a special bill about the private sector and how that should be, we must make sure then that we don't. We must enable it in this process, Chairperson. Create a situation that as if it's not even in consideration. So that's that. So I differ. I think going forward on this one, if they differ with me, I recommend, Chairperson, that the National Treasury must, because they also don't have the competence to interpret the law. They don't have the competence as National Treasury to interpret the Constitution. The only body that has got the competence to do this is a court of law. So I am recommending that the National Treasury must take that clause in the Constitution and take it to court just for a declarator. We're not arguing, we're not fighting in court. We're all on the same side. We're saying, court, please interpret this for us because we've got divergent views. Others think it's just for public service. Others think it's for South Africa. Can court please rule on this one? So I'm asking I think let's take this matter to court for a proper interpretation. And then also, I'm saying, Chairperson, let's be clear that we can't sit here and argue this today, because National Treasury is not the custodian of interpretation competence. So their interpretation is just their opinion. It's not an opinion that is binding on anyone. So let's go and get a binding opinion from court. That's the one thing. Next point, Chairperson, on the schedule of things that are being repealed or amended to ensure that there's uniformity. I want to argue, Chairperson, that CIDB, the proposed amendment in CIDB do absolutely nothing to create uniformity. That CIDB is standing on its own, is doing its own thing. It's almost like a tender board or something. I don't know how it got missed out in being repealed entirely. So I'm saying, Chairperson, we can't say we have a law that is trying to create uniformity, but still allow CIDB to continue in its current form. CIDB is nowhere near everything else that we're talking about here. It's got its own rules, it's got its own regulations, it's got everything about CIDB. It's very different to anything that we've dealt with here, Chairperson. If we had time, I would even tell you all of those things which are not provided for in this legislation. So, Chairperson, I'm saying that it is dishonest to say we're creating a law that is uniform, but we still leave CIDB. It is a misnomer. So it must go, CIDB, and be everything around contractors and everything must also be as provided for in this bill. Mustn't have a separate CIDB thing on the side. On Chapter 4, Chairperson, I agree with the submissions. Is it by a few people? One of them was, I think, Dr. Kondweni, that on that section 18, is it subsection 1, that may is wrong. It must say must. Because what are we doing here, Chairperson? The whole purpose of this exercise is actually to achieve transformation. So if you are going to say transformation and you still say may, what do you think you're doing? You know, so it should be a given that that thing must be a must. So the issues about those preconditions or set-asides, it must be a must. It can't be a may. It can't be at the discretion of someone that does not want to transform. And then also, Chairperson, on Section 19, subsection 1A, the issues of, I think that formulation there is opening a door for mischief. You must remember that the minimum levels, if we say a bidder must show a minimum level of compliance and then can tick a box. Now, of these levels of compliance, Chairperson, we've got, I think, 1 to 8, where 8 is actually the people that are not serious about life. But it is a level nonetheless, but it's really where you've not done absolutely nothing. We've done absolutely nothing. But if someone is going to be technical, as we've seen, people, they read these things and become very finicky about these things. If we say the requirement is to show that you've got some level of sorts, and you can tick a box that you've got some level, and so on. I'm arguing, Chairperson, that that's not sufficient. I think if we are making a law that is serious, there must be a minimum threshold that, for instance, I would suggest that any supplier that is not level 4 must not do business with government because they're really not serious. I'd compromise and say level 5, but strictly speaking, the government should only be dealing with level 4, level 3, 2, and 1 only. Others that don't want to transform, the state must not have any obligation to deal with those people. So I'm saying that 19.1A is a backdoor where somebody's going to say, well, the law says as long as I can indicate I'm level 8, which means nothing. So I have a problem with that. And then lastly, last part one, Chair. On the designation of services, I think we cannot continue as lawmakers, Chairperson, to do things that are not consistent with what we have committed to do at a broader level. At a broader level, if we said that we wanted a developmental state, wanted a state that has wanted to build the capacity of the state. How do you do that? How do you say that? But when you do, you outsource the entire thing, as it were, and the state is left with absolutely nothing to do. So what we have in the offices of government, basically, you've got coordinators. You've got nobody in government that is able to do anything. We've just got coordinators, as it were. So we're suggesting, Chairperson, that what we should have in these designations, there must be services that are designated only to be performed by the state, Chairperson. I mean, things like closing potholes, we can go to detail about that, but the principle must be embedded. There has to be something that says certain services must be provided by the state, Chairperson. And without wasting time, even in apartheid days, by the way, Chairperson, wrong example, but an important point to make. In apartheid days, if there was a hail like we've just had recently, and the asbestos roofs had holes, the very next morning, Ikanda would be driving in Midlands there, closing, replacing those sheets of asbestos. And at the municipal level, they would have that minimum competence to do that basic thing. But this government now that outsources everything, writing a speech, you outsource, everything is outsourced. Really, Chairperson, we can't have a situation like this. And then we have such a high public service bill. What exactly are these people doing there? They're just getting paid to get others to do the work. It's wrong. So there has to be a designation of services that are state provided. Lastly, Chair, I think we must be honest in government. We must be honest as legislators. If on that section 18 we have sentences about targets about, call it women, black women. We've got targets about black women owned, black women with a disability, and then we've got black youth, and then just underneath each of those categories, you then have women, and no color is mentioned there. Why are you shy, National Treasury? Because if you said black women, and you say the definition is African, colored, and Indian, and then you say women, and you don't put the color, does that mean white women? And if that means white women, why don't you say so? So that we are clear that this is what you want to do. So why are we hiding things here? On those three categories, you've got people with disability, but you don't say which race. Yet you have a one above that where you've specified the race. So where you have not specified the race, what exactly do you mean? And I'm saying, if you are saying white, be bold, be honest, say that that's what you are saying. Don't leave it like this, Chairperson. So yeah, and the last thing, Chairperson, on the issue of representativity, all those sections in section 18, that chapter 4, in section 18, everything that says 51%, I'm arguing, Chairperson, that it is not consistent with the Constitution. I've read at least 3 sections in the Constitution that talk to representativity. So if you say 51% black, you are actually saying 49% white. This is what we're saying. Now, if you look at the state SA has given us some kind of a guideline in terms of economic active population of this country. And we know now, based on, and because state SA is another government department, so government department tells us that in South Africa, you've got about 80% Africans. You've got about, give or take, you've got about 12% coloreds, give or take, you've got about 8% economically active white people, give or take, you've got maybe about 3%, actually now 2-point-something% Indians. That is representativity as defined by another government department that everybody is using. So therefore, to now come to this public procurement bill and you talk about 51%, what informs that, Chairperson? Why 51? Why not 80% Black? Because then you are in line with the what representativity should mean when you deal with transformation. I want to argue, Chairperson, as I close, that to leave it at 51-49, it actually means white people are allowed to be represented in like 400% in these deals. Because, I mean, if you have a population here that is constituting, let me be generous, 10%, but we are saying that this 10% population in deals, in contracts, in all of these things, they must be 49%. This is what we are saying, but they are only 10. So in other words, everybody that is white is going to be covered. But here you have a chunk of 80% African. You have not even added the colored. Put the colored in there. You've got 90% Black population, as it were, that is there. And you are saying you just half of that, 51%. We are actually you're actually undermining the concept that is enshrined in the Constitution, which is representativity, and which I've highlighted 3 sections that in the Constitution that talk to it, Chairperson. So I'm saying Treasury must go to the drawing board on that 51% because it's unconstitutional, and they must be in line with the provisions of the Constitution and ensure that there's representativity. And Africans are 80%, if they don't know. Coloreds, about 12%. They can look up the numbers. Those are the kinds of realms that we should be working on when we deal with trying to redress the imbalances of the past, because this legislation, that is really what it's about. Yeah, I think that's it, Chairperson. And as I close, last sentence, I think this observation was made, I think, again by the Prof, which I agree with, that this preferential point system, again, is an introduction of triple PFA by backdoor. That entire thing must be removed, Chairperson. And as I say, I think the Prof must assist us to make a proper formulation, but I'm sure the EFF can make a formulation on this to ensure that price, which has been discredited worldwide as a criteria for preference points, must be removed. And National Treasury has introduced now triple PFA via backdoor. I think this is unacceptable. Thank you, Chairperson.
Thanks, Honorable Manyu. Issues here. Stakeholders, you are in the platform. Please don't make derogatory saying here is wrong. Please don't do that. Input. Then submission about the issue of the 40% set aside were conned by the statement of the president. My understanding is that women who are here in this platform and those who made submissions, written and oral, are representing their constituencies. And to such effect, I think we should respect their inputs. To say they are conned, con is a very strong word, Honorable Mine. It means somebody made them to believe something which is a lie. So I think it's not good to make such a statement, more especially to women. So I will leave it to you, but I thought if you apologize and we take it out of record, the better. But if it is left in the record of Parliament that you said that women were conned, it won't be good for you, and it's not good for women. It's to undermine the intelligence of women who have made these inputs. Over to you, Honorable Mike. Before I call Honorable Skosan on the issue of women being conned.
No, Chairperson, I insist they've been conned. I'm actually sympathizing with them because they took Mr. Ramaphosa's word for it, and they only discover now that none of what he's been saying on public platforms is true. They have been conned. It's really a fact, and it must go on record. And if there are consequences that I must suffer, I'm ready for that because this is the truth. Women have been conned. Women have been lied to. Women have been misled. They had high hopes. I saw them. They were very emotional about this matter, and I took that emotion into personally myself to say, indeed, the women of this country are saying, for a change, now something is going to happen. They feel so let down. I feel their pain. So, Chairperson, if feeling their pain is unparliamentary, then let it be. Then let it be unparliamentary. I think women have been conned, they've been lied to. Ramaphosa lied. He said 40% will happen, and none of that is happening on this proposal. So what's wrong with that? Let's stay on the side of the truth, not on political correctness. Thank you, Chair.
No. We don't agree with you. It's to undermine the intelligence and the status of women. You can differ with what the president has said, but for women to have made their input in their own right as representing their constituencies, to say, as women, this is mine, reflect on it, that's not a right statement. You can say something about your colleague, the president or us as members of parliament. I think let's proceed to other members to inputs. Thank you. Let's reinvite Honorable Skosan.
No, ngiyathokoza sihlalo ohloniphekileko. Ngilotshisa wonke amalunga ahloniphekileko abajameli be-National Treasury nama-stakeholders wonke akhona nabo bonke abakhona emhlanganweni. Yeah, no, Chair, I want to join other members in appreciating the presentation by the National Treasury on this bill, particularly in response to submissions that were made by various stakeholders. I think we appreciate the fact that we have reached this stage because this bill is long overdue. I think the ministry, the National Treasury, and ourselves as the committee, we've been talking about this bill for the better part of this sixth parliamentary term, which is coming to an end by mid next year. So we appreciate the fact that we have reached this stage whereby the National Treasury is responding to submissions by stakeholders. But I'm also agreeing with Honorable Maswale that I think there should be a way or means to also ensure that all other stakeholders are responded to, as the National Treasury has indicated that this response is to not cover all stakeholders due to the limitation of time on their part. So they could not respond to all stakeholders. So I'm appealing to them that if there could be means or ways to make sure that all the submissions that were made are responded to, so that all stakeholders can feel that indeed their inputs and submissions and concerns have been taken into consideration in the process. We also appreciate Chapter 4, which has been presented, that seek to remedy some of the defects and also accommodate some of the concerns that were raised by some of the stakeholders. Indeed, it is a step in the right direction. Honorable Chair, the bill in the main, I think it seeks to deal with, in my view, two things which are very critical. One is to fight corruption or to prevent corruption. Because sometimes there are perceptions that there's corruption in other institutions. There is that public perception. So I think having a bill like this, I think it shows, I think, the commitment on the part of government and the commitment on our part as the legislative authority of the state to say we want to have a legislation that will focus squarely on issues of procurement, which are most of the time a challenge, to an extent that there will be some form of centralizations and similarities, and there would be a dispute resolution mechanism like the procurement, the public procurement tribunal, that will be able to listen to disputes from suppliers or bidders who are not happy with decisions that have been taken by public procurement office. So I think, in my view, that will assist in dealing with corruption where there's any. See, so I think this bill is important in that particular aspect. But secondly, it is important on the aspect of transformation, as other members have indicated. And it's our responsibility to make sure that transformation takes place. And I agree with Honorable Manye that transformation is a constitutional matter. It's not just a by the way issue. It is a constitutional matter. And I think it's unfortunate that after so many years, we are still living in a society that is so unequal. So we've got to do all that we can in our powers to make sure that we deal with the challenges of being in an unequal society, so that we make sure that we are all able to benefit from the state. We are all able to get all opportunities that we deserve. And by doing so, we'll be able to deal with the issue of transformation, of transforming the society. So the issue of set-asides, which are there in the bill, we really welcome them, especially where it talks about the youth and the Black youth, women, and where it specifies and says Black women, people with disabilities and stuff like that. But I think the issue of Section 18, which some stakeholders have spoken to, we need to look at it, I think, as a committee, when we deal with clause to clause, just to make sure that we tighten the wording, where the wording is not strong enough to show that we are indeed committed to make sure that the previously disadvantaged do benefit. We will have to strengthen that wording, because it won't assist for us to pass a bill which, in our view, we think that we are dealing with transformation, but to find that it has some loopholes and technicalities which might make it not to be enforceable. So we've got to make sure that when we deal with clause to clause, we look at all those loose screws in that particular section and tighten them so that the bill become explicit on this issue of transformation, particularly in relation to Black people, which are the previously disadvantaged community. So I think we've got to look at that as a committee, because the bill is now with us. So we've got to tighten that. And the issue of value for money, Chair, in my view, value for money and transformation, they are not mutually exclusive. They can coexist. So the capturing that was there, that was saying value for money, which now the National Treasury is saying they've changed that to effective, efficient, and economic use of resources and stuff like that. To me, I think it means the same thing. Value for money and being economic, effective, and efficient, it still means the same. And in my view, there's no need for us to remove that in the bill, because that can coexist with transformation. Because when we say we are for transformation, it does not mean we are not for value for money, or we are not for the effective, efficient, and economic use of resources. No, we are for that, but we are also for transformation. So transformation and value for money, for me, they can coexist because they are not mutually exclusive. And yeah, one question that I have, it's on the issue of consequence management, which is one matter that was raised by some of the stakeholders during the public participation day, to say the bill seemed to be silent on what will be the consequences to those institutions who are not adhering to the expectations of this particular bill. What will be the consequences? So I think the bill need to also be explicit on that, to say which actions will be taken against such individuals or against such institution. And lastly, Chair, on the issue of which Honorable Mani also spoke about, of extending the bill to also include the private sector, which was raised, I think, by some of the stakeholders. I think for me, it is an important matter that the private sector ought to also be regulated as far as these matters of procurement are concerned, because the perception of corruption around the issue of procurement is not only limited to the public sector, but is also there in the private sector. However, I don't agree that we should include that in this particular bill, because one, I think I think we are far in terms of stages. We are almost towards concluding the processes. So if we are to cover and accommodate the issues of the private sector, I think that would require more time, because the public sector and the private sector, they are distinct in nature, because as we know that the private sector in the main is profit orientated, whereas the public sector is more about service delivery. It's more about the efficient, effective, and economic management of public resources. So if we are to include that in this particular bill, though it is possible, but it might take us time. We might have to give Treasury time to go and look at the aspects that might affect the private sector and incorporate them. We might have to have another public participation process where we'll have other stakeholders that in the main are economic active in the private sector to also give their input. So I think that will totally delay the process. So my view is that that it is important to be regulated, but we might need, in my view, another bill that will specifically focus on the private sector. But for this particular one, let this one focus on the public sector, remain as a public procurement bill, and let us just get responses for the outstanding stakeholders, and then from there take the process to the next stage where we will deal with clause to clause and tighten the loose screw where it seems to be confusion, or where the clauses are not clear, are not giving a clear directive, because that might lead them to be abused or to different interpretations. So my wish is that we need to pass this bill before we finish our term, because we've been talking about it since the beginning of this term, which is the 6th administration. So my wish is to see the bill being passed before the end of this particular term. So let the National Treasury do their part, and then we also do our part to make sure that we conclude and submit the report to the National Assembly. So thank you very much.
Siyathokoza njalo. Honorable Abraham.
Yes, Chair, thank you so much. Chair, maybe first and foremost, one wants to really appreciate the wisdom that has come through in this public hearing through the inputs of the stakeholders. And I think it's quite critical and appreciated that they are able to know that when the president has spoken, the task lies with the department to ensure the interpretation of the statement of the president by law. And this is what this bill seeks to do. And it is appreciated that the stakeholders are holding the department to account, which is a platform that is democratically created exactly for that. The Treasury has got a responsibility to ensure that what the state president has outlined find interpretation and implementation in legislation like this one. I agree with Honorable Skosana that this bill is long overdue, because if we are a government that seeks to change the lives of the people, therefore we need to bite the bullet and ensure transformation, because we need to be deliberate, especially when it comes to transforming our economy. The best way of doing that is to ensure maximum participation of the majority of the people who have in the past been left outside. It's a complex bill, but it is a bill that is needed for transformation. And therefore, Honorable Skosana, through your chair, it is a bill that will be a legacy bill, because I can count 3 or 2 ministers backwards who started with the discussion of this particular bill. And therefore, let us appreciate the seriousness of the ANC government and the president of our country in ensuring that we not only come up with transformation of the economy, but we are deliberate in placing women, in placing previously oppressed people, in placing previously discriminated people at the center of economic activity. And issues that have been discussed by honorable members that include set-asides and local procurement are quite critical, and a fair discussion is needed. And I think I saw on the platform that one of the stakeholders, for example, is proposing a kind of a forum that will take the form of a workshop just to ensure that we are all on the same page in terms of what needs to happen. However, in the same breath, we are saying whatever needs to happen, transformation must take place because time is of the essence. We have said a lot about transforming the economy. It's time to do. And for everybody, the redrafting of chapter 4 is quite critical. And as the ANC, we want to support that. My question, Chair, is how will procurement be dealt with at local government level when the procurement officer is housed in National Treasury? This is, for me, a question of clarity. But I agree, this is a debate that you must allow to flow going forward until we have achieved economic transformation. I thank you, Chair.
Enkosi, Honorable Abraham, Treasury, before I adjourn the meeting, do you want to make comments?
Thank you, Chair. Thank you very much. And I think we welcome the comments from the stakeholders, including the comments by the members of the committee. Now, Chair, let me start at the end around the issue of completing responses to the balance of the submissions that we made. I think we would be guided by the committee and the chair on what we should do in that respect. Then with me, Chair, I have also my colleagues who may also want to respond to some of the issues that have been raised. But in a nutshell, Chair, I would just say maybe if they are there, they can come in and comment. But from my side, I think we definitely appreciate the comments, and they make sense. And then also just indicate that, as we pointed out earlier on in our opening remarks, that of course it was due to time constraints, of course, from the date of the 13th of September, the last day of the public hearings, we've been working flat out to make sure that this will respond each and every response thoroughly. But what I want to say, Chair, perhaps before the stakeholders could make follow-up submissions, maybe it would be incumbent upon them to also read the comment matrix, if that is allowed, Chair, so that the stakeholders could appreciate the responses that went into some of these comments. I think it would be important to do so, Chair. And then from our side, we've taken note of a number of comments by the stakeholders and the committee. And just in short, Chair, we, of course, being directed by the chair and the committee, we will then have to relook at the gaps that are there. And that is my submission, Chair, without taking much of your time. Thank you very much.
Are you done, Mr. Matebula and your team?
Thanks, Chair. Yes, but I appeal that some of my colleagues who are part of this process also be afforded an opportunity. You know, of course, if they would also want to make comments, Chair. Thank you very much. But from my side, I think that's it. And I do have some of my colleagues. Maybe if I may just ask the advocate van Schoor, the first one, to just come in and also make short comments. Thank you very much.
Good afternoon, Chairperson and honourable members. No comment at this point. I think we need to consider all the comments, that's received, and also from the public stakeholders and from you. I think the important thing for us is now to hear how much time, we would have to consider all the other comments. Thank you.
Or you want? The Chief Procurement Officer is also here with me. Maybe she would also want to say one or two words. Thank you very much, Chair.
Thank you, Honorable Chair and honorable members. I concur with my colleagues that yes, we have had the comments, but it would also be important that we do look at the matrix that we have provided. And perhaps just to go past the issue of the value for money, I think it's quite important we'll be unpacking that once more, because if we look at value for money, as we all know, it does focus on obtaining the best possible outcome in terms of quality, performance, and the cost effectiveness from procurement activities. So we are making a leap in terms of not only looking at the price, and we're of the view that if we prioritize value for money, the public procurement processes, they would become more strategic, efficient, and outcome-oriented, which is what we trying to have now. We'll have the key aspects that relate to value for money, and we can share with yourselves in the next session, where you'll be talking around issues of when you talk on optimal allocation of resources, and what is it that we'll be talking to, competition, cost reduction, quality and performance. All of those issues, we can be able to unpack them in the next session that we'd have. So we do concur with the issue that will not necessarily be more price driven, which to a very great extent, which is what value for money is, it does look at the economical, efficient, and effectiveness, and it closes that with the equity component. So we can a little bit unpack, not necessarily the fact that we'll be putting it in the bill, but in terms of the regulations, as we have already said, that we can put off on how that will be done, and we'll be able to again get some comments, as we have said, in terms of the regulations. I do take note in terms of the proposal that has come through in terms of the workshop on transformation, but will also be guided by yourselves, Honorable Chair, when you wish to have that. But you should also just allow us, because we've got at the moment a lot in front of us in terms of just finalizing these comments that are in front of us. I think I'm covered, Chair. Thanks. Chair, are you still there?
I thought there's still one or two of your colleagues who want to make input. If you are done, you can indicate so that I can move to the next item.
Yes, I'm through, Chair. Thank you.
Okay. Thanks very much, honorable members, for your inputs, clarity-seeking questions and comments. And thanks to the stakeholders also for your constructive inputs. From here, what we'll have to do, having heard some stakeholders raising the issue of responses from the side of National Treasury, we'll hold a special meeting next week, that Thursday or Friday, for National Treasury again to deal with issues that stakeholders feel have not been dealt with. But what you must understand, it does not mean that if you make a submission as a stakeholder, government will 100% agree with you. It's your submission. At the end, National Treasury will respond as they understand issues of procurement, and ultimately, Parliament will pass the bill considering all the inputs. So it should not be that National Treasury, you have not taken my issue, so this bill can't proceed. That's not how we process the bill. Be that as it may, so that we are not seen to be a parliament that does not consider issues raised by the public. With the Secretariat and call a special meeting, even if it's at night, for National Treasury to deal with certain issues. Then on the other week of the 28th and the 29th, the committee is going to consider the bill clause by clause and ultimately adopt the report. From there, the report will be taken to Parliament. So that's how we're going to process this bill. Thanks very much, honorable members, stakeholders, media, public, and support teams of Parliament, and in particular, SCOF support team. Let's adjourn the meeting until we meet again in the next meeting. Thanks.
Long live the chair.
Thank you, Chair.
Thank you, Chair.
Bye.
Thank you. Goodbye.
Thank you.
Thank you. Bye.
Recording stopped.